Okay, we're ready?
Yes.
All right, good morning, everybody. Welcome. Thank you for being here today. This is the special magistrate hearing in the town of Pembroke Park for Tuesday, May 18th, 2021. I am the special magistrate today. My name is Rafael Suarez-Rivas. Turn off any cell phones. Do not interrupt the proceedings. No weapons are allowed in the town building. As to the issues that come up, we ask that everyone show mutual respect and listen to the person speaking, and that everyone refrain from any clapping, heckling, or verbal outbursts in favor or opposition to any speaker. The hearings are conducted by the special master to give the alleged violators the opportunity to contest the decision of code enforcement, which has resulted in the issuance of a violation. The hearings are conducted in a quasi-judicial manner. I am the special master assigned to hear today's cases. I act very much like a judge in a court. I hear evidence presented by code enforcement officers and any contradictory arguments presented by alleged violators. Hearings are open to the public. All persons who testify on these cases are placed under oath, including code enforcement officers. Hearings are not conducted in accordance with formal rules of evidence. Any relevant evidence will be admitted if I find it to be competent and reliable, regardless of the existence of a common law or statutory privilege. All documentary evidence must be submitted for placement in the hearing file or have been submitted earlier. Documentary evidence will not be considered unless the alleged violator or code enforcement officer submits a copy for the hearing file. Parties shall have the right to call and examine a witness, to speak, to introduce exhibits, to cross-examine opposing witnesses on any matter relevant to the issues, even though the matter was not covered in direct examination. It is my responsibility to make findings of fact based on the evidence of record. My fact-finding determination is limited to whether the alleged violations have occurred or not. If so, whether the persons named in the civil violation can be held responsible. I may also modify the decision of code enforcement as to the time for correction, even though that time is rebuttably presumed to have been reasonable. I have the authority to assess and order the payment of civil penalties, to issue orders having the force of law, and to do whatever is necessary to bring the violation into compliance, including the ability to access administrative costs. In order to uphold the code enforcement officer's decision, I must find that there is competent, substantial evidence that the named violator was responsible for a violation of the relevant codes. If I affirm the decision of code, I will specify the amount of the civil penalty, the administrative costs of the hearing, which are going to be $100, the date by which the violation must be corrected or cured to prevent resumption of continuing violation penalties. Any aggrieved party, including the town, may appeal the final order of the special magistrate to the circuit court. An appeal is not a new hearing, but is limited to an appellate review of the hearing before the special master. An appeal has to be filed within 30 calendar days of the issuance of the order. The orders will be announced here at the hearing. They'll either be given to you if you're here. If not, the town will be mailing a copy of the order later to you. Again, if you are found guilty of a violation charge, the administrative fee that is charged by the town is $100. The city representative will present their case first. The alleged violator will present their case thereafter. I will consider the evidence and render a decision after all arguments are heard. Thank you. Roll call as to code enforcement people present, please. Please identify yourselves.
Chief Code Enforcement Officer Jocelyn Ramirez.
Code Enforcement Officer Jeffrey Lewis.
Are there any changes in this agenda, that is to say, anything that is being deferred, continued, removed, et cetera?
Yes, there's 3 cases that's going to be deferred, which is
Tell me the case numbers so I can find them because of the agenda.
okay. It's 5049.
On what page of the agenda is that?
3, page 3.
5, 0. Looking at page 3, I do not see 55049.
At the bottom of the page?
Yes. Is it? Does it?
Why don't you go up there and show him? Go up there and show him.
Okay, it's on page 4, sorry. All right, so what do you want, that to be continued?
Yes, to be continued until the next special magistrate.
Case 5049, which involves 2400 Southwest LLC, is hereby continued to the next magistrate hearing.
The next one is case 5116.
Yes, case 5116 will be continued to the next magistrate hearing, and that again involves 2400 Southwest LLC.
And the third case is 5117 on the next page.
Case 5117, 2400 Southwest LLC will be continued next magistrate hearing. Thank you. Anything else?
No, thank you.
Okay. Now,
Question.
yeah,
What if a case has become full compliance?
case has become into full compliance. When that comes up on the agenda, that can be represented, and case could be considered.
Okay, thank you.
If that's confirmed, you can announce it now, and the case can just be removed. You know, so what case is that?
That's case 5509.
What page is that on? It's on page 2. It's Pembroke Park Holdings.
Yes.
Are there any outstanding issues with that case whatsoever? Any?
No.
Case 5509, Pembroke Park Holdings, Inc. is removed from the docket. No action will be taken on it. Case considered dismissed. That dismissal is, of course, without prejudice in the event there's other violations prosecuted. Anything else on the agenda? That's it? Okay. Anyone who is going to be speaking today is required by law to be sworn in. That's anybody, including code enforcement officers. If you're going to be testifying today, please raise your right hand, or you can testify, and affirm that the testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God. Please say, I do.
I do.
Okay, thank you. All right, we can commence with the agenda. I'm going to take it in the order in which people are here, based on a sheet that was given to me.
Special magistrate, if you please can use the mic.
Hello? Is the mic on? Right. We're going to go by an order of the people that are here, and the case will be presented that way first, and then we'll return to the order on the agenda. First, we have case number 5699. And I want to find that on the agenda.
That's on the 5th page.
Which Page?
Fifth page, number 6.
You are, sir?
Attorney Mark Grimes, representing Rollins.
Okay. First, we're going to hear from the town, correct?
Yes.
All right.
Code Enforcement Officer Teresa Malcolm, representing for the town of Pembroke Park. For site address 1820 Southwest 30th Ave. Rollins Continental Inc., aka Orkins. Case number 5699. The initial notice of violation was written on March 24th, 2021. It was given regular mail for the following. The sidewalks and parking lot had rust on them with cracks, also a broken fence along the property line. There was excessive use of prohibited storage. Also, there was a generator that needed to be verified if it was permitted. There was also a storage pod in the parking lot area. Notices were given for the formal hearing via posting as well as certified mail.
Do you have any communications with the owners or their agents?
I was able to communicate with Mr. Grimes last week for the property. I went out, well, the pictures of the original state of the property are on the screen. I went out and I did a re-inspection on the property last Friday, the 13th. There are a couple items that have been addressed since my visit, which were the sidewalks being pressure washed. A couple of the prohibitive items of the parking lot were removed. The pod was also removed from the property. A lot of the dead vegetations were picked up and removed from the property. The rest will be addressed, but we are in communication.
What are the remaining open violations?
The remaining open violations are for them to obtain a building permit for the restriping and paving of the parking lot. Also, for the remaining of the prohibited items to be completely removed from the parking lot area. As well as the maintenance and the painting of the building, as well as the sidewalks.
Did you do a recent re-inspection?
Yes, I visited the property on the 13th, last Friday.
And were those violations still existing?
The only violation that still exists as of today would be the painting or pressure washing of the building, as well as a couple more items that need to be completely removed from the parking lot area.
Now, I don't want to be confused. When I asked you a moment ago, what remained, you said building permit, repainting, piping, parking lot removal of items, maintenance of building, and sidewalk.
Correct.
All those still remain?
Yes, correct.
Okay. And those were all cited?
Yes,
They have not been corrected.
correct.
What, in your opinion, is a reasonable time for correction?
My recommendation would be for 30 days to have everything completed.
And, what is the proposed penalty, or what is the prescribed fine for the penalty violation?
It would be $50 per day.
For each violation?
No, for the complete case, the overall.
Commencing in 30 days.
Correct. Not at this time.
Kirk?
Good morning. Let me just begin by saying we have been cooperating over the past week or so with Teresa Malcolm on this. One point, I noticed the notice that my client was responding to was dated April 29th, 2021. I did not have the benefit of seeing the earlier, I think you referenced a March notice. The only one we had in our possession was the one from April, which basically detailed the same things Ms. Malcolm laid out here. Like I say, we've been working to cooperate and get these addressed in an expeditious manner. I provided via email a copy of the paving agreement with DMI Paving, who will be pulling the permit to begin that work. That contract was signed, I believe, in early May, and they're saying it'll take a couple of weeks before they can get to it. And I have an extra copy of that with me if you'd like it.
I have it here. Was dated May 12th.
May 12th. So that's for the parking lot striping and paving. In terms of the pressure cleaning, some of that has already been done. I've been advised by Mr. Barboza, who's sitting there, he's the Orkin representative, that he just spoke with the contractor, and they're going to be pressure cleaning the sidewalks today. So that's going to be done. In terms of pressure cleaning the building, they've asked for an estimate to do that. I would point out that the notice that we got didn't specify that the building had to be pressure cleaned. It only referenced the sidewalks. But that being the case, we're certainly prepared to do the pressure cleaning of the building if that's a violation that was found last Friday, as far as I understand.
Pressure cleaning of the building cited in any notice?
No, that was discovered upon my visit on Friday. It was,
We can adjudicate that.
okay.
So that's out. As for the other violation, the order is going to provide, based on the testimony of the officer and the evidence on file, that as to the repaving, piping, parking lot removal of items, sidewalk, painting, pressure cleaning, sidewalks, those are open violations, about findings of fact and conclusions of law set forth in case law and code inspector's report. I find that those are violations of the town code. They have to be corrected within 30 days of the issuance of the order. If not, a per-day fine will commence the 30th day from the date of the order, 30th day and each day thereafter. $100 in administrative costs as provided for in every case by the town is additionally assessed. Is there anything else?
The only thing is I want to make sure I did provide a copy of the permit for the generator. That was in the initial notice.
Yes, I did receive that.
And finally, the removal of the pods on the thing, we also provided an invoice
Yes,
for that.
I received that.
So just so I'm clear, Magistrate, there's a $100 fine that we have to, or processing fee that we have to pay.
There's a $100 administrative fee as prescribed for all the cases that are adjudicated not in favor of a violator.
Okay.
And in addition, there'll be a 50-day per diem fine commencing 30 days from the date of the order, and each day thereafter until there is full.
And one last procedural question. Once we have that lined up to have it pressure cleaned, we can contact Ms. Malcolm and she can come out and take a look at it to verify.
Right, yes.
Perfect. Thank you.
Yes, I will.
Next matter that we have,
The next on the list is 4933, but we would like to hear 4634, which is the same attorney, Mr. Ship. 4634 on the first page. Right, it's not written on the list, but it's the same attorney.
Mr. Ship, you want to come up? So, this is your item. Special magistrate, this is.
I'm not prepared to go forward on this today. Is there,
No, we're just gonna hear the continuance. And then then you've got a second outstanding violation that you got a notice of.
oh, that's what I was here for, the 4933.
But discussed, you've got there's an outstanding amended final order, which was, Mr. Hearing Officer, let me go ahead, I'm gonna put the town's case on.
Mr. Magistrate, in all due respect, that's not on the docket for today. I have no problem speaking with counsel after the hearing
I
here.
informed you in the email, in writing, that we were gonna be discussing this today.
I wasn't aware that we were going to be doing a formal hearing on this
We're
matter.
just discussing the order that was incorrectly entered, which I told you in writing we were gonna do.
What we have on the magistrate agenda today is, town's motion to vacate the amended final order.
Correct.
That's what's on the agenda, so we can,
All right, so
That's
let me
been
go ahead and
noticed for-
present my case. He can present his defenses or what argument, whatever he has when it's his turn.
right, no, that's fine, town attorney. Is there a proposed order on this or not? Not right now?
Not,
Not right now.
because I
Okay,
don't
yes.
know what the outcome's gonna
Right,
be.
right, yes,
so
I understand, I understand.
Okay, so I'm gonna give a little background. Do you want to introduce you?
I'm not even sure what we're,
Okay,
if we're even
this
having a
is
hearing,
Mr. Schiff.
if we're having
He
a hearing or not.
represents
Lakeshore Mobile Home Park?
Lakeshore Mobile Home Park. Last hearing, he was here. He asked for a continuance for the case 4634. Or the town, in error, entered an amended final order instead of an order for continuance. The town is here asking the hearing officer to vacate that order and to enter an order for continuance. What that's my ask. My question to Mr. Ship is, your continuance, which would have been 30 days from the date of the last hearing, basically has now expired. So what do you want to do at this time?
Okay.
Okay, so I'm asking you to vacate the amended final order and enter an order of continuance. That's my ask. I'm gonna go ahead and sit down. He can respond.
Okay. So as counsel correctly stated that there was an error on the order last time, just so you're aware, the order came, the hearing was on I want to say the 12th of April, if I'm not mistaken. That order was essentially hung on to until I believe April 28th, and then it was presented to my client, not me of counsel, and I did state on the record, and I've been in contact with the town for about a year. We ended up getting that order on a Friday of last week, I believe, or I'm sorry, 2 weeks ago on a Friday. I immediately, it was late Friday, I immediately called up the town, and I stated that the order is incorrect. On a Monday, I said, can you please have the order corrected? She stated she'd try to get it done by the end of the week. I said, I don't want to have my client prejudiced. Can you please get this order corrected? She said, by the end of the week. I followed up on Tuesday, the following day, to see if it could be corrected because there was an error in it. I looked at it that my client was put in a position where, there's a possibility that the magistrate would not correct the order, and we were forced to file an appeal. I had spoke with counsel several times trying to correct the order, and we ended up filing an appeal. It looks like she's asking that it be corrected now. So if it's going to be corrected now, we appreciate that. I wasn't prepared to go forward on this today. I would have liked to have my other hearing first, but I guess this is where we are right now.
Right. Based on the representations of counsel and the statements on the record, and I am going to enter an order vacating the order of April 13th that was entered apparently mistakenly or inadvertently in this case, and that order is hereby vacated. I think that I want to, I invite any town attorney or you, sir, but I think just for the record, to make things clean and to avoid any other confusion in this, the simplest thing is just to set this matter for all I see today is clearly the motion to vacate, and I'm always concerned with, that's all I see on this agenda, the motion to vacate. So I'm just concerned.
Okay, can we just deal with this, and then we can deal with the other active
Yes.
item? Is that
Yes.
acceptable?
Yes, that's acceptable.
So I would ask, so I'm gonna ask Mr. Shipp, when do you now want your continuance to go to? Want it to the next hearing date?
You know, if we're going to be, again, I'm being blindsided. I didn't know we were going to have an actual hearing on this today. I thought we were going to speak maybe in quarters or something after this, but here we are.
Mr. Schiff, I don't want to interrupt you, but I'd like to be efficient and expeditious. I have listened to you, and I did listen to the town attorney. I entered an order, just now you heard me, vacating that. That is adjudicated now. That order is going to be vacated. okay?
Understood.
So now we're just talking about the other open violation.
Well,
and-
we've gotta get so that order is vacated, but but there is an order of continuance that needs to be entered from the last meeting, because that's what was supposed to be entered. So what I'm asking you, Mr. Shipp, is, that's all we're talking about. We're not talking about the other violation now. Jocelyn, what's the number of the other violation? Do you have that?
Yeah, it's 4933.
4933. Okay, we're not talking about that. We're just talking about the order that was incorrectly entered, which has just been vacated. I'm not going to go forward on that. I'm just asking you, when do you want your continuance to for that particular case?
I'd
Do you want it
like,
30 days
sure.
from now?
I'd like to have the matter continued until the town can provide myself and my client with a compliance plan so that we can come into compliance, because we've been asking this for literally over a year, and that's...
Let me explain the procedural. He wants to now get into the substance of the matter. So I'm going to get into the substance of the matter. The substance of the matter is that in January of last year, and we've got this order in the file, there was proper notice and a proper order entered as to the substantive portion of this case. There was a factual finding they were in violation. Then they did not come into violation, and the fine was instituted. So to give you a broader view of where this case is, Mr. Shipp has a client, and he's got a fine running on this case. It was brought before the magistrate in April in order to confirm that fine so a lien could be placed. That was the time that he asked for a continuance, and the town agreed, and there was an order mistakenly entered. If and when this case comes back before the magistrate, it's not going to be heard on the merits. It's not going to be heard from the record. All we're asking the hearing officer to do, and all we were asking the special magistrate to do in April, is to confirm the fine. So if Mr. Shipp wants to contest the validity of the underlying notice of violation, then he needs to appeal that, which goes back to January of last year.
I think I understand, counsel, and
So that's not part of this case. The only thing we're discussing today is the order, which was entered in error last month, which you vacated, and then we need to put a continuance order in place so that we can hear the confirmation of the fine. That's it. There's no adjudication of the merits. That's already taken place. That took place in January of last year. So, now, the other case that you have coming up, yes, there is an adjudication on the merits for that. If you want to continue both these cases for 30 days, that's fine. I don't have a problem with that, but let's get down to the nuts and bolts of where we are.
Okay.
Right, and if I, again, not to unduly consume I understood counsel, I believe, but this matter, 4634 is here for is either we'll call it a fine certification or a fine confirmation, call it what you will, but being conversant with code enforcement procedures, I'm sure you are, sir, we're not going to relitigate.
I understand. Here's.
So we're not going to go there.
I understand, and I'm not trying to do that. All I'm trying to do is, I have a client who is not a client who's not trying to do something. They want to come into compliance, they want to make good, they want to reach an agreement. I have been literally working on this for over a year, okay? And I mean, I have, and the town attorney, since she's been a part of the team, Jocelyn can attest to that. All we need is, and all we're asking for, is to have some type of compliance plan so that we know what we have to do to get this done.
We're not going to relitigate or get back into, I am presuming, and again, this precedes me, but I'm presuming there's some kind of compliance schedule or something in that order, or there's some kind of discussion on that, but, you know, if that is not there, that's not something for me to get into here, you know? So I think the question now is, quite simply, sir, give us a date for this item to be continued, and then we can have the hearing that was supposed to be scheduled. Please give us that date.
60 days?
Is that too long, Tom?
We would prefer 30 days on both items. I think Mr. Shipp and the client have had plenty of time to adequately, or will have plenty of time to adequately prepare for both of these items at that time. That's the only thing I'm willing to agree to.
Mr. Magistrate, can we meet in the middle at 45? And I'm just being completely frank and honest. Like, we're having difficulty, and again, this might be outside of this hearing. We want to reach a resolution. We don't know, like, exactly what we have to do. That's all we're asking for.
Well, that, you know, again, my
Yeah,
powers as
I
a
got you.
magistrate are limited. I'm not
I
here
understand.
as a super commissioner.
Uh-huh.
I have no oversight of the town. We're just talking code enforcement.
Understood.
My order is, because I want it noted, you know, the vacation of the record, based on all the representations of the record, I take note that this matter goes back to January of 2020 or earlier, and it's now a year and a half earlier. So I think under all those circumstances, 30 days, if this was like some kind of newer thing, I would go with you, Mr. Schiff, but under those circumstances, 30 days, I think, is eminently reasonable. This matter is continued, and is the other matter even on the agenda today?
It is, but we will agree to a 30-day continuance for both, just to get them.
Actually, I would like to hear case 4933 separately.
I'd like to hear that separately.
Correct.
I'm gonna draw my agreement for the 30-day continuance on that item, and I'll agree to a 30-day continuance on this item, and then I'll have to talk to staff outside about the other item. So let's just deal with this item
All right,
right
so
now.
this item, the order is vacated, and the matter is continued for 30 days until the next scheduled hearing before the magistrate, not earlier than 30 days, put it down. You know, next scheduled
Yes,
hearing, okay.
yes.
All right, that's good, that's what we're doing here now. Thank you, sir.
So both cases are,
No.
No, just case 4634.
okay, because I could have sworn, okay.
I withdrew my agreement for the continuance on the second one because staff wants to hear that. Let me discuss it with staff outside for 5 minutes. We're going to call 4933 now. Yep, this is you again. The county,
I'm sorry,
back in my county days.
what,
John,
That's page number 2, case 4933. You're welcome.
Town would like to proceed with this case. There is proper notification, but I guess Mr. Shipp is going to ask for a continuance from this case. So I don't want to state his request for him, but.
Page number 2, and the item number 2, case 4933. Oh, Mary, can you please help Special Magistrate find the order? Yeah.
4933, you said?
Yes. Chief Officer Jocelyn Ramirez
Let him find first,
of the Town of Pembroke Park. I'll just present the case.
but let him find.
Okay.
figure out what
It
he's
should be
doing.
the second page. Case 4933, site address 2701 South Park Road. The initial notice of violation was given February 13, 2020, by regular mail. And the notice of formal hearing with the notice of violation was given certified and by posting. On May 3rd, 2021, sorry. Posting was on May 10, 2021. The initial violation was written for blight, damage of roof panels, damage of walls, damage of ceilings. Building is in need of pressure wash and painting. That has been complied. Prohibited outdoor storage, that has been complied. Dead vegetation, that has been complied. Addition, interior, exterior renovations, doors, drywall, cabinets, ventilation, security cameras, electrical and rails done without permit, that has not been complied. And right now, there is pictures that depict the violation at the time it was written in February 13, 2020. And what the current property looks like today on May 10, 2021.
And when you did a reinspection?
Yeah, that's when the reinspection was.
And what were the
Well,
findings?
the initial reinspection when everything was complied was April 24, 2020. And I did a recent inspection on May 10, 2021. That the addition, interior, exterior renovations, doors, drywall, cabinets, ventilation. Okay, ventilation, security cameras, electrical cameras, and rails that were done without permits are still pending to be applied for a permit. And everything else has been complied. What I just said. Addition, interior, exterior renovations, doors, drywall, cabinets, ventilation, electrical security cameras, electrical inside the property, and rails done without permits. Yeah. All right.
What do you think is a reasonable time for compliance?
Well, since the initial violation was written back in February 13, 2020, I'm recommending, and this is a repeat violation, I'm recommending 30 days to comply and $100 per diem commencing the day of the order. No.
Sure. So again, on this one, I've been trying to reach a resolution for over a year now. You know, she's showing that there's 14 different violations, and as you can see, my client completed most of like the aesthetic corrections like immediately. So when Ms. Ramirez came out there, I think in April of 2020, she could see that obviously most of everything has been completed. As to the additional violations, just so you have some background, my client acquired this property in 2007, and this alleged addition was there prior to them taking title to the property. So here we are from 2007 to 2020 when they come out and they're finally cited for this alleged violation. We've just been trying to clarify what actually needs to be done with the town and try to reach a settlement agreement for this case and the other case. And you know, everything has just fallen upon deaf ears. And here we are a year later, and I've instructed my client at this time is to just go ahead and do what you think you got to do here, because we're not going to get anything from the town. And that's kind of where we stand right now. And the issue that they're having is they're trying to get contractors out there, and it's very tough right now because labor is very hard to find. So that's where they're at. They have some bids on the or they have some bids out there. Is that correct? Two bids. I think the project, which we think to correct the violations, it might be around $30,000. But the whole issue is we have no problem trying to work with the town. We just don't know what exactly we need to do. So I think today is the most progress we've made in the last year, because now we understand that most of those violations have been stripped off. So. So, I mean, are we asking for a continuance? I'd say we don't necessarily need a continuance. We're just asking for, I mean, maybe 60 to 90 days so we can pull the permits, lock in those bids, and do the best that they can, because we're not going to get any further direction.
Professional staff person, when did you say the first violation?
You said mobile homes?
Of the open violations
On this case, February 13, 2020.
Turn off your cell phone. I find that there's been a little time here. Nature of these violations has been approximately a year and a half. As to the open violations, based on the testimony of which is rebutted by code compliance, of ventilator security cameras done without permit, interior and exterior renovations done without permit. Rails done without permits. Those don't seem like extensive matters to me. And you said it's a repeat violation. Based on what is it a repeat violation?
Based on the other case that was heard earlier, 5634.
They're wholly unrelated.
Right, but the repeat violation, if it's the same owner and same code.
Your Honor, as you know, state law provides that for a repeat violation, the same owner repeating it, we can
Yeah, I mean,
count it as a repeat violation.
I would just like to put on the record is, you know, it's not like they're not trying to do something. I mean, I don't know what else more I can do except continue to email and call and ask to set up, phone calls, but all I've asked to do is to settle this case. And I mean, I have all the email correspondence here. I don't know what else, I mean, our hands are tied because we're not getting any direction, and it just continues to drag out, and we're just kind of like, we're at a standstill here. And if we're going to be forced to, try to come into compliance with, we don't know what all the violations are, but if we're going to be forced to come into compliance, we're just asking for, I would say, 60 days so we can at least try to get the contractors to pull the permits and attempt to do what they're going to try to do. And hopefully it cures, the alleged violations.
Violation is defined in Chapter 7 of the Town Code, which of course the magistrates rely and adopt the Town Code, and Chapter 162 and all procedures and regulations that are in conducting these hearings. Speaks of a repeat violation by a person whom is found to have violated the same provisions in the past 5 years prior to the violation. Have they been found to have violated the same provision? When and where?
The last case, 4634, was in the past 5 years, and so has this one too, case 4933. At this,
4634, and I don't mean to be argumentative, I go by the law. 4634, the order was vacated, we haven't heard back. So I'm asking, is there some
the
other?
That
the
was just
amended
a-
final order was
That was
vacated.
just on a confirmation of the lien. That was not a vacation of the original order.
Okay, I see what you're saying. I see what you're saying. Okay, right. I understand. How fast is this?
No, it's okay.
Okay, and that earlier order, which was entered last year, has to do with same violation,
Same ordinance, yes,
same ordinance, and it's the same person.
yes.
I'd like to see that. And I'm unclear on that.
That's in the record. So, I'm not gonna, that's a representation sworn by the town. I'm not gonna dispute it. That's been made on the record. So I find that is a repeat violation under the town code. So consequently, I think that this has been going on for quite some time. I am going to find that there's a violation as described by the code enforcement officer and detailed in the testimony and in the evidence of record in the file, and that this is a repeat violation. It's going to be $100 per diem fine, plus a $100 administrative fee. I don't believe, frankly, this is my personal, that absent an emergency or public health situation, I usually don't make orders immediate. What is the shortest time the town thinks that is logical for compliance?
30 days.
So within 30 days, that's the order, sir. Within 30 days, there has to be compliance. If not, the fine will begin to run. I am entering the order, and unless you want to mail this order to the violator, a copy has to be tendered right now.
Right, we're going to scan the copy and we're going to hand it to him right now.
If you want to wait, they'll have the order for you.
Yeah, otherwise I'm not going to get it, so.
I will mail the order of continuance for the last matter to you when I know on record, next magistrate's hearing, that's coming up, but it's a mean confirmation, not a full-blown factual hearing.
Oh, I mean, I didn't have the history of this violation.
My apologies on that.
No, it's, I just,
I was blindsided too.
Your Honor, may we continue to the next case?
Yes. let's go.
Okay, case 5409. Please. That's,
Page 4. Thank you.
That's correct. It's on page 4, case number 5409. Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park. Case 5409 is for Seneca Industrial Park, Industrial Holding, in which the tenant is Window Classics. This is located at 2401 Southwest 32nd Avenue in Pembroke Park. This is a violation in regards to section 5-2, which is no building permit for an AC. Affidavit of service was given as of May 11th, which was posted onto the property. The initial violation was written on October 27, 2020, and referencing to a AC that's located on top of the roof that was completed without a permit. The initial permit was pulled in January 24, 2018. However, that permit expired due to lack of activity. At this current time, a new permit was submitted. A permit application was submitted to the building department, and currently it is in plan review.
Is that the only violation
Yes, that is the only violation for this property.
here? And what would you recommend in terms of compliance with your unpermitted AC?
Given that they already submitted a new application to process, I would say 30 days to obtain the permit and complete inspections. Otherwise, it would be a $50 per diem until the violation is in compliance with a $100 administrative cost.
Thank you. Anything else on that?
No, that's it.
Sir, do you have, give your name and address, your relationship to the property, and tell us anything about it.
Yes, I'm Joe Garcia, and I am a president of Window Classics. We're the tenant on the building.
Tenant in the building.
Yes, and the owner's representative is also here, but I was authorized to sign for the permit back in 2018.
You're authorized, you don't have a power of attorney?
I'm the the owner authorized agent to pull the permit.
All right. Go ahead.
So we did have a permit on this. We thought the permit was closed out. We had some issues apparently with the flyer. Something was changed in the code that did not comply. We were not aware of this until, we received this violation. We contacted our AC supplier here around the clock. They dragged their feet a little bit on getting this permit redone. And now I guess from what I understand is the permit has been applied for. There is some work that needs to be required, some lines to run to connect the new AC. And we don't know if that's going to be able to get done, obviously, in these conditions, within 30 days. But we're prepared to, finish the job and close the permit.
This initial violation was, you said, on October 27th of 2020?
Correct, October 27th of 2020.
And getting this permit is a relatively straightforward, right?
Correct. It's the permit application and all the paperwork to show how it's going to be connected And that, like I said, that has been submitted with the building department to process under plan review.
Based on your testimony, the record, and your service I have listened to, it doesn't appear that this is, a Durham kind of permit or an environmental or an expensive permit. I think that the 30 days is reasonable. Under the circumstances, I do find and do conclude that there is a violation of the code section as cited, and is included in the record. I am going to still find you have 30 days. So to secure the permit, if not, there will be a $50 per day fine, plus the prescribed $100 fee for all cases. That is what the order so provides, and unless you are given the order right now, a copy will be mailed to you.
So just so I understand, so 30 days is to obtain the permit, then I've got 90 days to call for the first inspection, for the inspection?
You have 30 days to call in for your inspections and complete the permit. Otherwise, $50 per diem will start to accrue.
Right, to get the work done. also.
Typically, if there was no violation,
Problem is, I can't hire the sub until we have the permit, so he can't, officially, I have no contract to get the work done.
Sounds to me like a straightforward permit. I know what an AC permit is. I'm sure you think 30 days is reasonable. I do. In your experience, that's not enough time. Tell me,
how much additional time do you think you would need?
I haven't called again the fire person, the sprinkler company, to find out, but under these conditions, most times they don't even, talk to you. He's the one that has to make that connection in order for me to call the final, or for air around the clock to call the final. And I'm just, I can't call him and even give him a permit number at this point, so I don't even have that permit in hand. So I would think, in an additional 30 days, we should be able to get it all wrapped up.
So 60 days to comply?
Town agrees with that?
Yes.
So, the order will provide that you have 60 days to, from the day you're hearing, to have, the work concluded, permitted, approved. If not, there will be a 50-day per diem paid in fine, commencing on the 51st day. And there is a $100 administrative fee. Right now. And that's what the order will provide. And again, if you say you can get a copy of that,
I'll go ahead and wait for it.
Your Honor, may we continue to the next case?
Case number is 5409.
if you may,
Okay.
tell me,
Case 5068.
what page?
That's
Page
page
one.
1.
Morning.
Sir, have you been sworn in?
No.
Affirmative testimony. Anybody who's come in here who hasn't been sworn in, raise your right hand if you want to speak. Anybody. Affirmative testimony you will give is the whole truth. Nothing but the truth, so help you God. Can I do?
I do.
You.
Good morning, Magistrate. My name is Miguel Nunez. I'm the Chief Building Official for the town of Pembroke Park. And right now I'm bringing the case 5068 for the address of 5401 Southwest 25th Court. This is a violation to the Florida Building Code, Section 110.15, released with the 40-year safety inspections, AKA 40-year, in building. 110.15, 110.15. On the Florida Building Code, Broward County Administrative Provisions. This is a 40-year safety inspections are required by the Florida Building Code. This particular case started back in 2020, where as regulatory conditions, we notify the customer or the owner of the property when the building requires the 40-year inspections as notified by the Board of Rules and Appeals and the property appraiser's office. During that time, in December 23rd, the letter was sent, and then they never responded, so the notice of violation was sent in May 11, 2020, because they did not conform to the requirements of the 40 safety, the timelines. Later, the application was received in December 23, 2020. Unfortunately, the application was denied for incompleteness of the inspections, which constituting structural and electrical disciplines. The comments were notified to the applicant, AKA owner, on December 28, 2020. Unfortunately, the applicant never responded or never responded to the comments that it was presented, and the application became null and void in February 28, 2021 in the provisions of the Florida Building Code, Section 105.3.1.1. After that, the notice of hearing was mailed by certified mail to the owner on 5/05/2021. I'm sorry, the notice of hearing was prepared on 5/5/2021. The certified mail was mailed in 5/06/2021, and it was posted on 5/10/2021. You have photos on record. And at this point in time, we are requesting the magistrate to find cause on this, and we find an order for 30 days compliance, $100 administrative fee, if not $100 per day, failure to comply within 30 days.
You say cost besides the
Administrative cost, yes, sir.
You move the administrative.
Administrative fee, yeah. Sorry.
Is there anything else you want to say?
No, sir, at this point in time, no. This is a very, the 40-year safety inspection, as you know, constitutes structural and electrical safety components in the building. So in my opinion, that's our life safety items.
Yes, I understand. That is a license. All right, thank you. Sir,
Yes.
you are, give your name, your address, the property, and go ahead.
Sure, my name is Kurt Vogel, 3625 North Country Club Drive, Aventura, 33180. I'm the owner's representative. He's currently out of the country. I have a 40-year inspection here for structural and electrical. This was emailed. I emailed this to Jeffrey last night. I did because I was asked by the property owner to send this to him. So I don't know if this is what you need, or you're telling me.
Is that the corrected one? Or that's just the same one that it was submitted before?
I don't know. I'll be very honest with you.
You can put it this way, in terms of the code enforcement hearing, I'm going to defer to you, Mr. Building Department. If you want to review it now, and you can make that determination, that's fine. If not, it can be submitted into the record. It can't be considered unless it's submitted into the record. And the order would provide that there has to be 30-day compliance. So that would be up to you. It would be your burden to contact him.
Okay.
And see if that is a compliant instrument under the Florida Building Code or not. If it's not, this order is going to provide that, based on the, and it is my order, because, you could have, again, not to, I don't want to seem like I'm criticizing anyone here or anything, but if it was me involved in these things, I would be reaching out to the town earlier and trying to submit these documents earlier and getting a response earlier before we're here right now. So it's probably unfair to ask him to make a snap decision on that. So I'm gonna find that, there is a violation of the Florida Building Code, based on testimony and the evidence of record, and, you know, it could be quicker, but, you're gonna be given 30 days to ensure that you have a 40-day building recertification compliance. It is a public health and safety measure. If not, there will be a $100 per diem fine commencing on the 31st day of the day of this hearing, plus a $100 administrative cost. You can submit those items into the record if you care to, and the building official will, I'm sure, consider them and make some determination. But meanwhile, I have entered this order, which you're welcome to take with a copy with you if you want to remain here a minute, and if not, it will be mailed to you.
Magistrate, can I add, please? I would prefer the property owner's agent to submit it on the record via the normal building code proceedings. We are very, very fast on the town of Pembroke Park, and I don't think that will toll any time afforded by these proceedings on the 30 days. Other than it will be documented, and it will be appropriate in accordance to the Florida Building Code, Section 105.
Section 105 of Florida Building Code, the other section noted, I take administrative notice. I understand what the building official's saying. That's what you're going to do. What he's saying is you should submit it in the record into the online building application permit system the way everybody else does, and that way it is in the system and can be reviewed normally, as opposed to just handing it over to him here at a hearing outside of the system. I understand what you're saying. I appreciate it. That's what you need to do, sir. Am I clear?
Yes, just to, let's say this is incorrect. You said the problem was originally it was, refresh my memory so I can write this down. The application was null and void because it was not put on the proper paperwork?
There were comments on the original application based
Okay.
on the incompleteness or some aspects of the form.
Okay.
We have a record, so if you wanted to know, we can give it to you again. That time, because you or your applicant did not respond within 60 days in accordance to Florida Building Code, it became null and void. Therefore,
Okay.
it's constituted work without permits or non-compliance in this particular case. Now, if you submit, when you submit to the building department this particular new evidence that you have of the new 40-year inspection recertification, if they are in compliance, they will be approved. If they're not, you're going to receive new comments.
Okay.
But be aware that those new comments will have to be responded within the 30 days allotted by the special magistrate.
When this is submitted, which is going to happen today, how quick is the turnaround?
Normally, the turnaround is you're going to submit it to the building department. They will put it on the system, and I should be reviewing that either tonight or tomorrow.
Okay.
Well, I go by worst case scenario, unfortunately, but in the worst case scenario, it will be by Friday.
Okay. What is your name, sir?
My name is Miguel Nunez. I'm the chief building official.
Okay. And to contact you is just call the building
Just
department?
call the building department.
Okay. Thank you, sir.
Thank you, sir.
You have any other questions? Now's your chance to ask them.
No, I'm going to submit this, and I guess we'll be in touch.
Thank you, sir.
Thank you very much. Okay. Thank you.
Sir, before you go, are you still representing the other case for 5382? For the same owner?
I didn't even know we had a
You're
case.
not aware of that one?
No, what is
Okay.
that? What is that about?
Okay. I don't know if you'd like to stay and represent the case. Just wanted to let you know.
5382, yes, I mean, I guess so.
Tell us what case that is and where, on what page.
Okay. That's page 2, item number 4.
Item number 4, that's case 5382.
Yes.
Yes, YM, right?
Yeah.
What was this one? Oh, this is 5401, okay.
The first case was 5068. That's what.
Correct, that's the other one, right?
Correct.
Thank you.
Chief Code Enforcement Officer Jocelyn Ramirez, case 5382, site address 5401 Southwest 25th Court. The initial notice of violation was given on October 13, 2020. A notice of formal hearing was given on May 5th, 2021. It was sent out certified mail May 5th, 2021, and posted at the property on May 10th, 2021. There are pictures for the record that depict the violation on October 6, 2020. And upon reinspection, May 10, 2021. The violations are for operating without a business tax receipt, exterior maintenance required, repair of the concrete in the driveway. That actually has been taken care of.
Concrete in the driveway has been taken care of.
Has been repaired, and
Exterior maintenance.
the exterior maintenance is still pending. With, they have to pressure wash and they have to paint over the chip paint.
And the business tax receipt is still pending.
Right.
And what else?
There's constant trash and debris on the property and overgrown weeds. The property owner has to maintain the property periodically.
And that's required by the code?
Yes.
And are these four things that you said, operating without a PCR, exterior maintenance, trash and debris, and overgrown weeds, all in violation today?
Yes.
Was there a fairly recent or recently inspection?
Yes.
And did you find these violations for this?
Yes.
Okay, I'm sorry, is there anything else you want to add?
No.
And what do you recommend as to these violations?
I recommend 15 days to complete everything in 15 days. If not, commencing at $50 on the day of the order.
From the day,
From the day of the order. $50 per diem
from after the 15 days.
after the 15 days.
Anything else?
Nope, that's all.
Sir, please, again, give, if you don't mind for the record, your name, your relationship to the property, again, and what you want to say.
Sure, owner agent, my name is Kurt Vogel, 3625 North Country Club Drive, Aventura, 33180. I have to discuss this with the property owner. I do know there was a problem with the garbage. There were other parties throwing garbage into this, and we did speak to Waste Management about putting a lock on the garbage, because we did have a problem with overflowing garbage. That I do know. These other things, you sure? I know the building was painted recently. And so were you
It's the
speaking about
driveway.
the front or the back?
The driveway in the front.
Because the whole front of the building was just repainted in the last few months.
On, yeah,
Can I see the photos that?
yeah, you can see them on the
Oh, they're
screen.
over there, I'm sorry. Can I get a copy of these photos, or?
Yeah. You give me your email.
Sure, it's just CURT 3000 @gmail.com.
Jeffrey has it too.
Okay. All right.
And
Go ahead, email them, so.
there's no trash bin or anything outside.
Okay.
I recommended to the tenant to put a trash bin for his delivery guys to, have somewhere to dump the trash, because it's
Okay.
always on the floor.
You're speaking
Constantly.
about the front or the back?
The front.
The front, okay. And this operating without a business tax receipt, that's the property owner? Or
That's the tenant,
The tenant, that's what I thought. And then why would this fall on the property owner?
because it's his property.
Oh, he has to enforce it, okay.
That's who was cited, and that's who was,
Okay.
and just like the garbage, even if it's garbage that sadly comes from elsewhere, some bad neighbors or, but if it's your bins on your property, regardless of the origin of that refuse, it's your code enforcement.
Okay.
Your Honor, I've been there multiple times. It is not coming from the neighbors, it's coming from the delivery trucks. And the delivery trucks have personnel have attest to it too. There's no trash bin, nothing that is put into place to collect the trash.
Okay. The on- The only thing I ask is if it's at all possible, give me more than 15 days, because as I said, he's out of the country, he's not coming back in 15 days. So I need to get the appropriate.
Unfortunately, this has been dragging since October 13, 2020. So I think that's sufficient time to clean up the mess and obtain the business tax receipt. I mean, the tenant already started the process, he just needs to complete it.
Oh, the business tax receipt?
I'm going to agree with the town. Fine amount is actually modest. This has been pending. Now it would be more or less 7 months for BPR, exterior maintenance, crash and debris, overflow leak, things that very simple to comply with. So I'm going to agree with the town in this instance over this. And you're going to have to comply within 15 days. And if not, there will be a $50 per diem fine. Starting on the 16th day. So you need to call him, or, you know, if you need an authorization from him, these are all pretty simple things. Someone has to attend to it right away. And $100 administrative fee for everything. And the order so entered, so provide, and if you want to remain a moment, you can get a copy, or it will be mailed to you. Thank you.
Okay, can I clarify, you said pressure washing, no painting, correct?
No, I said painting as well.
What do you want need painted? Because as
The
I said,
driveway.
this is just painted.
The driveway, there's chip paint everywhere, that needs to be maintenance.
You're speaking about the driveway, the
Yeah,
ground,
the
the
docking
floor?
station, yeah, for the delivery
Oh,
trucks.
the dock,
Look, if you could see in the picture. There you go. Where the paint has chipped, that has to be
Over there.
maintained.
Okay. All right, and you're going to email me these photos, right?
Yes,
Okay, thank you.
you're welcome.
Ask any questions you have now, if you want to right now.
So I do have another question. So between now and 15 days, if this is all taken care of, contact the building department? I don't want to hit 15 days and you tell me
You
there's something else that
contact
needs to be
me
done.
directly,
Do you have a number? Or?
yes, 954
Yes,
551
yes.
47.
I'm sorry. I didn't hear the last 7 something.
7147. I'll give you my
Oh,
business.
okay, thank you very much. Appreciate it. Thank you. Okay, thank you. All right, that's it.
Thank you.
Okay, thank you very much.
Did he get his final order? Yeah?
Yes,
Okay.
yes.
May we continue to the next case?
I'm going to continue to the next case. Tell me the number and what page.
Okay. Case 4794,
Page 2.
page 2, item 1.
Relly Torres.
Good morning.
Have you been sworn in?
Yes.
Okay. Case Code Enforcement Officer Jocelyn Ramirez, case 4794, site address 113 Lone Pine Lane. The property owner, Arielise Torres. The initial notice of violation was given December 13, 2019, and was given by hand and regular mail. The notice of formal hearing was delivered by certified mail on May 5th, 2021, and by posting on May 10th, 2021. Okay, There's pictures in the record that depict the time of the violation on December 13, 2019. Yes. There's pictures from a reinspection on January 15, 2020. And
January 15, 2020.
yeah, I did 2 re-inspections.
January
2020.
2020 is a year, is there a more recent reinspection?
Yeah, May 10th, 2021.
From that one.
Okay.
The other one
Okay.
is outdated.
All right. Okay, the violations were for a shed, door, fence, 2 carport, window, and rail altered without permits. The owner has obtained permits for the carports, the door, and what's pending is the shed, the window, and the rail. So we need permits for those.
The open violations today are the shed, which was not permitted,
Mm-hmm.
the window,
Mm-hmm.
which was modified or altered,
Correct.
and the rails, which were not permitted.
Correct.
That's what's open today.
Yes.
Is there anything else you want to add now?
No.
What are you recommending?
I'm recommending 30 days and a per diem of $50. Since the initial violation was on December 13, 2019.
The violation goes back a year and a half, really.
Yes. I'm sorry. I'm actually recommending 45 days. Sorry, I just saw my notes here. I'm recommending 45 days because the owner has been communicating with me. She is helping. This is actually the owner's mother. So she's here on behalf of her mother. And she has, yeah.
I just went next door and,
Well, please, now we'll hear from you, but start with your name, your address, your relationship to the property.
Absolutely.
Go ahead and say what you want to say.
absolutely. My name is Arelis Torres. I'm the daughter of Arelis Torres. We're both named the same mother and daughter. I've got the NOA that I just printed from next door for the window and the one for the rails. And I have a meeting on Friday at 7:30, this Friday at 7:30, so they can help me fill out the proper documentations for those permits. Now, as far as the shed house, there is an issue with the shed house because when the property was purchased, I obtained the blueprints, and the walkthrough through the permits showed, the lady explained to me that the shed house was part of the permit at that point in time. And these are the actual blueprints of the property, if I may.
I imagine that what you're getting at is an argument or grandfathered, or that the shed was in the original permit. I don't want to support you about that.
I'm sorry?
You're saying the original shed was permitted somehow.
Yeah, it's on the
We need
blueprints.
building official for that.
And
The building official?
We need someone from building for that. I'm not gonna, that's gonna require.
Right. She will have to clarify that with the building department. I know the building manager and the building official have told her that
yeah,
that
he's told me that it's not on there, but it's on the blueprints.
that they will not accept that because that's not that those plans in particular are not saying that is a permit for the shed.
So,
So-
Okay, so what the town is saying, so you understand, now you're gonna have to remove the shed. It's gonna have to,
well, then, to be quite honest, I'm going to take this to the park, and the park is going to have to be responsible. I explained it to the young lady because she's been more than helpful. And they're the ones that are going to have to pay if they want it to be removed, or if they wanted to put it, and if it has to be up to code, then the park is gonna have to be responsible for this, because I have the walkthrough, and it was signed by, unfortunately, the young lady that did this for me passed away. So therefore, I don't think that my mom or I should be responsible for something
Well,
that,
but look, without meaning to advise you, because I can't advise you and I'm not advising you. Heading at is that you're somehow grandfathered or permitted, that turns upon whether the town, not that you put it on a plan, but that the town approved some town document that shed. So either that exists, or if it doesn't exist, you don't really have a viable grandfather argument, in my opinion.
okay,
And
I understand.
so somebody can say, you permitted this dock, which is not allowed, but if it's just a drawing of a dock, that's not a part. There has to be something saying approved, town, something,
Right,
So that's basically it. So
okay,
what the order is going to provide, so if you get that determination, I understand what the town is saying as well.
yeah, I do, I understand.
If building makes that determination for you, then you need to get that in writing, and that, you won't have to do that compliance. But
I totally
meanwhile,
agree.
the order's gonna provide that, based upon testimony here, what we have are windows, let's be clear, so you're clear, windows, the rail, and at this point, the shed. If you
Correct.
get the shed in writing for the town to accept that that is fine, then that's not going to, that's only, then you won't have to comply with that aspect.
I understand.
But if they don't do that, then within this 45-day period,
Right,
order, I do find, based on the testimony of the town, and you've been very frank yourself and candid, and I appreciate that, is that there is a violation of.
the shed house, Well, yeah.
The shed, the window, and the rails.
correct. Yeah, because the only thing was that we did not know that by replacing a window for the same window, we had to get a permit, because basically that's what happened. We just
You do.
took out the window. So then, yeah,
You do. So,
Yeah.
I mean, I know people say we didn't know, but I mean,
well,
so what the order is gonna provide is that you have 45 days.
correct.
Not,
And
there will
thank you
be
for that.
a per diem, $50, fine, if, starting on the 46th day.
Correct.
And you have to pay, the administrative fee of $50. And if you wanna remain, you can get a copy of the order now, if not, the town will mail it to you.
She can email me. We email each other.
The town prefers that you get a copy of the
Yes,
order.
she's gonna give you a copy right now.
Oh, she will? Oh, okay. Okay.
It's only gonna take a minute.
All right,
So
perfect.
you're gonna remain and get a copy now?
Yeah, yes, of course. And thank you.
Welcome.
I saw her, on Friday at 7:30. I'm gonna be in here, and the gentleman's gonna help me fill out the other form
Okay.
for the stairs and for the window.
Okay. Yeah. Your Honor, may we continue? Page number 2, item number 3, case number 5280.
Number 2,
5280. On number 2, item 3.
okay, I got it, thank you.
Have you been sworn in, sir?
Yes,
Okay. And you, sir?
yeah, he's with me.
Okay. Did you sign in, sir?
I signed for him.
For him?
No, I didn't sign his name, but I signed.
What's your name, sir?
James?
Your last name?
David
Bu-
Bullingham, right?
David Buchanan, 4502 Hallandale Beach Boulevard.
Yes, he's signed in.
Yeah, him, but the gentleman behind him didn't sign in.
Have him,
Yeah, I just put his name right now.
okay, let's hear it from code first, and then we'll hear from you.
Okay, case 5280, I'm sorry, Chief Code Enforcement Officer Jocelyn Ramirez, case 5280, site address 4420 West Hallandale Beach Boulevard, Numo Inc. The initial violation was given July 23rd, 2020, by regular mail. A notice of violation and formal hearing was given by certified mail on May 3rd, 2021. And posting on May 10th, 2021. There are pictures
Go to the pictures. please.
on the record to depict the time of the violation. February 9th.
Pictures, just let me interrupt to say that as we go through the cases,
Okay.
the pictures should be shown without, please.
Okay.
Right?
All right. So I don't need to state it for the record.
No, you need to state it for the record and the pictures. We want the audio and the video. We want
Okay. Got it.
the evidence that's stated,
Okay.
and we also want the photographic evidence.
Oh, got it. So, okay. So Teresa will take care of that when I state it. All right. The pictures are from February 9, 2020. Every inspection on September 2nd, 2020. This has been a series of inspections. There was also one on January 2021. Yeah, and May 10, 2021. Okay. So I'll go over the violations and I'll state which one have been complied. Okay, the violations are roof exterior requires maintenance, minor repairs, wash chemical treatment. That actually has been complied, but there are still some repairs that need to be done on.
Yeah, let's focus on the repairs that, and just,
Okay,
thank you so much. You're very descriptive. Do a bit slower.
okay. All right, roof exterior requires maintenance, minor repairs, wash and chemical treatment. The owner has washed and treated the shingles on the roof. However, the facades on the roof does require minor repairs.
So the roof, we want to focus on the open violations.
Right.
The roof facades.
Yeah. So those still require repair as there are lifting from, they have lift as depicted on the pictures. The walls require pressure wash and paint, front and back of property. That has been complied. Common areas require pressure wash. Sidewalks, poles, parking stumps, curbs. That has been complied.
So again, the open ones are the open ones.
So you just announced the open ones?
Well, yeah, I mean, you can say the, but in the order, we're going to address the
Right.
open, right? I mean,
Okay.
you can announce the ones that are.
All right. The potholes require repair. I know that there has been some that were repaired, but the property still has potholes that need to be addressed. Maintenance of signs. The sign has been removed. I believe there was a demolition permit pulled for that. However, the wall needs to be painted where that sign existed. And this particular property has had multiple accidents. One was in January, which left a lot of damages to the property. Those need to be repaired with plans and permit and inspections. And there's wrecked vehicles from the accidents that have to be removed from the property. And those violations, yeah, and those have to be removed from the property as they're prohibited from the town ordinance. And, nope, that is all.
And those still remain.
Yes.
Is there anything else you want me to add?
No.
And what do you recommend?
Okay. I know that recently the property owner has suffered another car accident. So I'm recommending 60 days to complete the violations, to comply with the violations. And if not, $50 per diem. No, that's all.
Sir, what do you want to say?
Okay, first, we'll start with the first one. It's the roof exterior. My name is David Buganim. I'm from 4502 Hallandale Beach Boulevard. Okay? The roof, as soon as we heard from Mr. Ramirez here, I hired a company. They came and cleaned, pressure cleaning. This is the gentleman. He did it once. I called Ms. Ramirez and told her that. She said it's not good enough. So I asked the gentleman, and he was kind enough to do it again. Okay, I have a receipt here from him, and he's going to talk to you about it. He's in the business for many, many years, and this is the second time he did that. Okay, I can show you the roof.
I have no objection. He did clean the shingles.
Twice.
We're talking about the facades.
Okay.
You see it right there, the
Yeah.
facades?
Yeah, it's nothing cleaning about that is going to do any good.
Right.
I mean, there's no
so
cleaning. You have to replace it.
As the violation stated, minor repairs.
Okay, it's not, you told me it's washing, cleaning. That's the reason I hired the gentleman. Okay, he's in business. He's doing this for years. He did it twice.
Right, and I understand what you're saying, but you have multiple violations, sir.
Right.
The fact that you corrected one, while it's commendable, doesn't excuse you for all the others. Were the repairs cited in there that were
Yes,
needed?
yes.
So you're on notice of that. It's not like it's been miscited. Do you not understand what you need to do for that, or? do you-
Yeah, I mean, she asked to remove pressure cleaning, which we did.
Right, we've been over that just now, so I don't want to repeat it. You have pressure cleaned, the repairs that remain to be done on the roof. Are you
Okay.
confused about that, or do you understand?
No,
Don't repeat the pressure
Right.
cleaning the third time, okay?
right.
You understand what repairs are?
Yes, I understand.
Okay. What is the issue?
First of all, the cars all removed. They've been removed for the last
As of
week now.
when? Okay, as I stated, the last time I was there, May 10th, they were still there.
Okay, you can visit,
So I can visit again the
okay.
property, and
It
if
is
it's been
some tenants
compliant, we
been
can
doing this
remove it.
thing, okay? It's not, now, for the last 3 months, we had 2 major accidents on the property. So that's not, we were about to start repairing one accident, then two weeks ago, we got another accident, major accident, a person died. Okay, so now we have other stuff, the same lights was blown up again. And the floor,
Why are there so many accidents on this property?
I called DOT to find out because it's the second accident, 2 people died. Okay, and the car flips over there. So,
They drove off of Hallandale Beach Boulevard into the ditch and landed into his property twice. Two
So-
separate occasions.
so the damage is still there. Yesterday I just got the accident report, which I have to call the insurance company to come down there and to inspect that, okay? So again, it's something that we were supposed to do, we were about to do, and all of a sudden we had another accident.
So, I mean, the accidents is a terrible, catastrophic, tragic situation in that property with this multiplicity of accidents. Sadly, it doesn't change the compliance aspect, though I'm mindful of it, but, the cars that have been involved in these, horrible accidents, I mean, are these the cars these aren't the cars that are trash there, are they, or?
I'm sorry?
This junk car business, the wreck vehicles. Are they the cars from the accidents? Or
Yes.
the cars
When I
Yes.
spoke to the owner, he said yes.
For the accidents, all the accidents, people,
Why is an FDOT or the towing, I mean, I don't understand.
I don't understand either, sir.
I mean, we call them.
I don't understand how everyone has been involved in an accident at some point in their life, oddly. And if the accident results, forget loss of life, but in a car being inoperable, the owner or AAA or someone has to remove
And there were about 7 cars
7 cars?
originally, the first time,
Well, I
yeah.
don't-
So they removed them, but it took some time. Some of them, were not, they parked there for a couple of days, I guess,
I don't understand.
Okay, this has been removed already.
Right. I don't, no, you can't.
Mr. Reyes.
Officer, you can't speak from there. If you need to come
You
up
will have to
and-
come in the podium and state your name. Okay.
It's just very curious to me. I don't, but, what else do you want to say?
Well, this is probably miscommunication because, she told me to clean and wash, pressure clean the roof, which I did twice. So what I have to do, I can't do more than twice, and every time I do that,
But again, we're getting into the pressure cleaning thing again. She said there's no violation for the pressure cleaning. Ms. Ramirez? I don't want to get into the pressure cleaning a 4th time, really respectfully.
that's what I understood. That's what I understood.
Okay. No, but if you look at the, citation, one, I think people should know, if they go on the town link, you can check on these cases and check what your violations are, if you somehow don't know, but, we're beyond pressure cleaning, that's been done. I think the issue was roof repairs that are needed. So,
It says here, wash
what
chemical
else do you-
treatment.
What else do you want to say?
It says minor repairs, comma, wash chemical treatment.
Right, which you did, so maybe, if she was more specific to the roof, exactly what, I would have done it. I mean, there's no problem. Every time she tells me to do something, I run away and do it. I mean, I'm not here to, I always would like to work with him. And every time they tell me to do something, I jump the first day, okay? And when she told me, okay, the problem is the roof again, this gentleman didn't have to do that. It just did it second time. He's a professional guy. And he told me, if you do it again, you're going to ruin the roof because you keep putting chemicals in the roof. It's not going to help it.
I don't know what else to tell you here, except where I sit, all I can say is, the town, I think would be as restrictive as they can be on these things, but I'm not, you can't, I'm not gonna tell them how to do their business this way. All I can say is that what I would encourage you to do is to speak in advance of the hearing, or speak at the time you're cited, to avoid any of these misunderstandings. Because if there was a miscommunication here, I'm sorry, but I understand that the pressure cleaning is not the same thing as the roof repair.
So when I called, you should have, explained to me that it's not the chemical stuff, that's why I didn't have to do it again. If I knew that, I wouldn't.
I happen to agree with you, so, but here it says, again, it says, it says, roof exterior requires maintenance, minor repairs, comma, wash or chemical treatment. So, it can mean both things,
I understand, it's all, but as I said, I called twice to inform her that I did it twice. All I had to do is tell me, okay, you did this, but you missed this one, or do this one differently, because I keep doing the same thing.
Right. No, I understand your frustration, and I appreciate it. I just don't know what I'm not here I'm here simply to adjudicate the cases. I'm not here to, I'm not, I understand, I'm sure your point has been heard. What are you recommending on this order?
As I mentioned, since he has suffered another car accident on the end of April, I'm recommending 60 days.
order, I'm gonna find that they're, based on the testimony, unrebutted, what there is outstanding is only, and please note, minor repairs.
Do I need to pull a permit for the minor repairs?
You have to check with the building department. It always depends on the scope of work.
Wrecked vehicles have to be removed. If they haven't been,
They've all been removed.
we'll be sure that, just be sure that they're gonna re-inspect. So just be
Sure.
sure there's not any other single wrecked, inoperable junk vehicle there. Damage from the car accidents.
Yeah, I mean, it just happened 2 weeks ago. As I said, I just received the accident report yesterday.
You're gonna be given 60 days to do these things.
Well, it takes probably longer because the insurance company has to come and inspect it, and then they will have to allow me to,
How much time are you requesting?
I need at least 90 days because they have to.
I won't object to that. So, 90
All right,
days.
You're gonna be given, the town agrees to your request, because we wanna wait for the insurance company to first front the money, that's up to you, I'm not, that would not be required for compliance, but that's, and the town agrees. So, you're gonna be given 90 days, 3 months to comply. If not, there's going to be $50 per diem. And, $100 administrative fee. Hereby enclosed. If you want to remain here a moment, say so, and you will get a copy of this order now. If not, it will be mailed to you. Do you want to stay a minute and get it?
Yeah, it's just going to take a minute.
Okay. no
Yes?
problem. Yes,
Okay,
thank
right,
you.
Because if not, you're gonna have to
Thank
mail
you,
it.
James.
So, all right, go ahead, stay, wait a minute, they'll give it to you right now, just wait.
Thank you.
5337.
Your Honor, may we continue? Okay. Case 5337, that's on page number 2. Yeah, item 5.
Raul Medina Jr., MTX Group 1 LLC.
Correct.
I wasn't signed in, he signed in, so should I give you my?
Yes.
Were you sworn in?
I was, yes, sir.
Counsel is here, like an attorney?
Yeah.
Likes to be here when there's attorneys. So you're the only one testifying today?
I mean, they're here if we need them, but.
Have you all been sworn in?
Yeah.
Okay. Okay. Counsel, what's your name? Did you sign
No,
in?
I'm not counsel.
You're
I'm
not
I'm
counsel?
property manager.
Property and your
On
name?
behalf of Raul Medina.
Your name, sir?
Mike Arguelles.
Oh, you did sign in earlier?
Yeah.
Okay, got it. Okay. Chief Code Enforcement Officer Jocelyn Ramirez. Case 5337, site address 2570 South Park Road, Raul Medina Jr., MTX Group 1 LLC.
Let's show the file.
So up top, just as I stated, just scroll as I state either the pictures or whatever. You scroll at the same time as I announce it. Okay, the initial notice of violation was given September 4th, 2020. It was posted to the property. The tenant at the time refused to sign it. And it was also delivered by regular mail. The notice of formal hearing with a copy of the notice of violation was sent out certified mail on May 3rd, 2021. And posted to the property on May 10th, 2021. There are pictures that depict the violation on September 3rd, 2020. A reinspection on February 23rd, 2021. And a final reinspection on May 10th, 2021. Okay. So, and the initial violation, there was a stop work order as there was work being done without permits. It was interior renovations, the restriping and seal coating of the parking lot, a prohibited banner sign, painting of the exterior without a permit. Right now, the only outstanding violations are the interior renovations without a permit. That's actually in progress. They did apply for a permit. The restriping and seal coating of the parking lot, they applied for a permit, but it's expired, so they'll have to apply for another one, according to the building department. And the prohibited banner sign has been removed. And
Sign has been removed.
yeah, and the painting of the exterior without a permit, they did obtain a permit for that.
So what we have left are the interior renovations unpermitted.
Correct.
And the restriping and so forth of the parking lot, also, not correct.
Correct.
Is there anything else?
No, that's all.
Is there anything you want to add? What are you recommending?
I'm recommending 30 days, if not a $50 per diem.
Sir, you are your relationship to the property and your business address, and then go ahead.
My name is George Matamoros, 2570 South Park Road, Pembroke Park. I am president of the tenant. President of the company is the tenant. And I'd like to make one question first, just for clarification, because we do have two. The other one is related, the same, so it's the same. But on the first one, on this 5337, the original, the letter says it had a 30-day to comply from the letter of this notice, which was 4/29. Today is 4/18, so those 30 days originally hasn't expired, or how do you count the 30 days?
From the initial violation of September 4, 2020.
But the note here
The
says that
notice
it's from the
of
date
formal
of this.
hearing,
Okay.
and it includes the copy of the notice of violation.
Okay, no, I just wanted to make sure, I'm just want to, To just clarify a couple of things, we do have a permit for the interior renovations, because I think.
As stated,
Yeah,
yes.
I think he might have understood otherwise. And we are in progress. As a matter of fact, we are calling inspection for different things. We had to add demolition and some structural to that scope of work that wasn't originally included, but that has
Alright.
already been completed. And also, we have applied, because you are correct, our striping permit did expire, but we have already closed the old one and applied for the new one, and as I believe it was in structural and zoning review as of yesterday. That's the last communication that I had from them, so I'm just waiting for that. But we did have communication with the town planner and some back and forth in email, just to make sure that what would be submitting would be adequate for it to get approved. So
Okay.
we tried to go through that route, so there's no, a bunch of comments.
Is
going
30
back.
days sufficient for you to complete it all?
As far as I'm concerned, I would like to finish it as soon as possible. I would just like to know one thing, that it has been a little hard lately getting some people to work because of the workforce and just the sheer thing that's happening with the industry, shortage of labor, people either not working or just being very busy. It is my commitment to get it done as soon as possible, but I would like to ask for a little more time just to be on the safe side, because I don't want to be back here.
How much
And-
time are you requesting?
60 days, although I would like to finish it, hopefully, if I can, way
Okay.
sooner than that.
I can agree to the 60 days.
Testimony and documentary evidence that I do find that there is a violation of town code as cited as to required restriping in the parking lot. Town code provides all parking lots have to be striped. Commercial properties, as to the interior renovations, maybe suffice for me to say that if they have been permitted, that was a little confusing to me, then that's fine. If they haven't, they need to be permitted within.
They have a permit. They have to complete all inspections. So when they get to their final inspection,
You have to, that means in terms of the order, you have to close the permit.
yes.
Correct.
So you'll have 60 days to comply. If not, there will be a $50 daily fine until there is compliance, and as prescribed by the town, there is an administrative fee of $100 per case.
Excuse me, I don't know, you guys did that before, but how and when is that paid? The $50, sorry, $100.
The $100 is to be paid within 30 days of the date of the hearing. I don't see any facilities for payment here now, so it would have to be paid within.
I'll reach out to the building department, and they might help me out.
Right, and after the hearing, you can see Jeffrey and he can take the payment, or
Sure.
I can take the payment as well.
And can we get 2 copies of the order, for one for the property owner and one for the tenant?
Mary, can you
No,
please go to the copier and make copies for him?
And
And Mary, just hold on, because we still have one more case for him, for the same party. So we're gonna have another order, and when we get both, then you can make a copy for them. May we continue to the next case? Case 5436. Page number 2, item 6.
5436. Thank you.
Okay, Chief Code Enforcement Officer Jocelyn Ramirez. Case 5436, site address 2570 South Park Road, MTX Group 1 LLC. The initial violation was sent by regular mail, November 5th, 2020. A formal hearing with a copy of the notice violation was given on April 29, 2021. Certified mail was sent out May 3rd, 2021, and posted to the property on May 10th, 2021. The violation was for operating without a business tax receipt. And as this current time, they can't obtain a business tax receipt until all the permits are complete. So they the department pulls a hold on it before they issue a business tax receipt. All right. Correct. So, so since the other case was regarding the permits, I would like your recommendation, should we consolidate the cases and have it 60 days or both of them 60 days? I mean, this case will be 60 days because they would need that time to complete the permits. Okay. No, this is a different violation. It's operating without a business tax receipt license. Right, this is not a repeat violation. This is just another ordinance. I'm recommending the 60 days, since it will take them 60 days to complete all the permits. And, it's redundant to say less days if they're gonna hold their BTR because they haven't completed the permits. So I would say 60 days, and if not, a $50 per diem. That's all.
George Matamoros, President, MTX Group 1, 2570 South Park Road, Pembroke Park. Nothing. I agree.
Okay, order, I believe that as the evidence has shown, testimony has shown that there's no business practices here as charged, there is a violation. There's going to need to be compliance within 60 days of today's date. If not, the respondent will pay $50 per day fine commencing on the 61st day, and the administrative fee of $100 is also now assessed in the order. So it is so done in order, and thank you for coming in.
Thank you. I'm sorry.
Again, for the orders, if you want to wait a minute, you'll get copies from the city of not noticing.
Agreed, and I just want to, may I have your card, your information, and one thing just for my future information, but the 60 days, is that counting full calendar 60 days or business days, or how does that get counted?
Full calendar.
Full calendar, okay. Thank you. Yep.
If you give Mary a moment, she's going to go to the copier. You said you needed 3 copies?
2.
2 copies each?
No, just one for him and one for me. Yeah.
Okay.
Oh, wait.
There we are. For the full list, yeah.
came down because they told me that they were. Let me watch it upstairs.
Magistrate, may we proceed to the next case?
If there's somebody here to present it, and I can find the order, yes, if not, you'll have to wait.
On page 4, number 2, case number 5039, Holly Ridge Apartments.
You may proceed with that matter, sir.
Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park. Case number 5039 is for Holly Ridge Apartments LLC, care of Elon Property Management. This is located at 3215 Southwest 52nd Avenue, Apartment 90. This is in regards to a notice of violation for interior and exterior renovation done without a building permit.
Let's go through the photos.
We have photos to enter into the record. The original notice of violation was sent on April 2nd, 2020. Then the notice of formal hearing was sent on May 5th, 2021. And an affidavit of service was posted onto the property with proof of posting on May 10th, 2021. Go down to the other photo. There you are. So at this current time, there is no building permit submitted to the town for the interior and exterior work of the apartment, and that would need to have a applied, permitted, and inspections to be completed in order to comply with the violation.
That's what's the open violation.
Correct.
Are there any other open violations?
No, just for the work without a permit, section 5-2.
And what,
The town recommendation would be for 30 days to apply for their permit and to complete their inspections. If not, a per diem of $50 per day and a $100 admin fee.
and on this case, said that the code section you're driving under on this case is.
Oh, I apologize. It's section 5-105.
Okay, right, okay.
I apologize about that.
Sir, your name, your address, your relationship to the property, and then whatever you want to say.
Yeah, Peter Vey, 1060 Northwest 66 Terrace, Margate, Florida. I work for Elon Property Management, who manages Holly Ridge Apartments. So, to apologize for the delay, because this is very old, this crazy job started out somehow with the painters painting an apartment. They opened up the drywall. They decided to remove the window. Crazy, but that's what happened. So they put it back together, and it took us, still taking us, although I have good news before I stop, a year to find a contractor that would get involved in it, because every time supposedly they called, they were told engineer, architect drawings were needed. So they backed off and wanted no part of the job. So that was the property struggle throughout 2020. I got involved because I knew, if you look at the picture, the roof is collapsing, and that's what was really causing the damage. So in January, we pulled the permit, we replaced the roof. If you went there now, you can look it up. It's a new roof, passed permits. So we figured the roof had to be fixed before the interior could be fixed, because that's what caused the damage. So that's where we are right now.
In the photos, it seems
Yeah, it looks like a car drove through it. But the roof is, I don't want to touch your screen, but you see that one piece of soffit that's hanging, dangling? That's where the roof was caving in. So why these painters decided to remove the drywall and take the window out is beyond anyone's comprehension, actually. But, of course, it was the roof that needed to be done first, you know? So,
that's really, I mean, I don't really know if it's fair to say that's really the painter. They shouldn't have exceeded their scope of work, but they're not
Correct.
roofers either.
right, so we've since replaced the roof. And since I got involved, because I wasn't involved during the previous year, so that the property manager struggled to find a contractor that'd be willing to take on this job once they found out engineering and all of that was required. So, you know, I got the roof replaced, and now I found someone I met last week. He provided with original as-is blueprints, and he's going to utilize that to make his drawings. He promises to have it on the desk of you, Jeffrey, within the next 2 weeks. So I hope that happens, and all I could do is stay on him, because I represent Holly Ridge. I'm not a contractor. So, you know,
I
Right.
appreciate
Yeah.
that you've been very open about this, and nevertheless, based on the testimony, the evidence, the facts presented, there's clearly a violation here. I certainly hope the property is not in this position now, but it's not habitable. It's seriously damaged. I'm going to enter an order recognizing this violation and concluding and finding that you're going to have 30 days to obtain the permit, okay? All right?
Right.
You're going to have 30 days. If not, there will be the $50 daily fine commencing on the 31st day. And stipulated administrative fee of $100 is imposed. And if you have any questions, I contact the gentleman from the city that is going to work with you on this, or ask him now. And if you want to remain a moment, you can get a copy of this order. If not, it will be mailed to you. Do you want to hang around a moment?
Sure, I'll hang
Mr.
around.
Vey, just verifying, you were sworn in
Yes.
prior to?
I was.
Just wanted to make sure that was on.
Yeah.
Okay.
All right.
If
So,
anybody left who's going to speak who wasn't sworn in, stand up now. If you've been sworn in, then that's fine.
Janeth and Mr. Anderson, have you been sworn in? Yeah?
5468, which is.
All right, yeah, okay, all right.
May we continue?
Yes,
Case,
page, please.
okay, number 2. Page 2. Item number 7. Case 5468.
5468.
Mm-hmm. Yes.
5468.
All right.
Go ahead.
Cape Code Enforcement Officer Jocelyn Ramirez, case 5468. Site address 3475 Southwest 52nd Avenue. The property owners Carlos and Maureen Brown. The initial violation was given on December 2nd, 2020 by hand and delivered by regular mail. A copy of the notice of formal hearing and notice of violation was sent out certified mail on May 3rd, 2021, and posted to the property on May 10, 2021. The violation was a stop work order. There was pouring of concrete to form a slab on the patio area done without permit. And verification of the shed for a permit for the shed, if it was installed with a shed, with a permit or not. As of this current time, the owner has not provided any documentation that there was a permit. The building department doesn't have any records of the permit.
So the shed appears to be unpermitted when a permit is required because the town hasn't found a copy of the permit and the owner hasn't.
Yeah, provided one, no. So it's an unpermitted shed.
So, an unpermitted slab and an unpermitted shed.
Correct. And there's pictures that depict the violation on December 2nd, 2020. And there hasn't been a reinspection since. And there's currently, well, I'm sorry, apparently Mr. Brown came in yesterday to submit an application for the concrete. And that's as far as the case has gotten since December 2nd, 2020. I'm recommending to complete everything by 30 days, if not a $50 per diem. Nope.
Sir, please, I know you are, but your name, your address, relationship to the property, and tell us what you want to say.
Yeah, my name is Magistrate. My name is Carlos Brown. I've owned or older of this property since 1999. I bought this place with the shed. In respect of the pouring of the concrete, I was actually told that we are responsible for the interior fencing of this patio villa. So instead of walking out in the dirt, I tried to fortify myself with concrete. They say ignorance is no excuse, but I actually didn't realize that I had was to pull a permit, seeing that it was the interior of the fence.
Cited on this originally, was it clear that one of the violations was the unpermitted laying or adding of the concrete without being...
Correct. There was a stop work order, and it was unpermitted work. The contractors were there, and I told them that they needed to pull the permit for the concrete slab.
Which I eventually did. Which I eventually did pull that permit.
As of yesterday, he submitted an application for a permit.
So that's not getting the permit. So let me tell you what we're going to do on this. I want you to understand.
Before you rule, sir, excuse me, I had written a letter to the stating my...
Your letter's in the record.
Okay. So that is why I even waited to see what would be the response.
Right, well, I can't, again, I'm simply here as a magistrate merely to hear the cases and find if there's a violation or not. I'm not, the town building official or the code compliance, a manager, or, I can't get involved as to whether they respond or, what, that's not what I'm here for. What I can tell you is the law, and the law is that for a shed, a permit is required. Now, if you're claiming that it was grandfathered, so you understand this, I think you heard me explain in another case, because this is not an uncommon issue, you need to provide simply a permit or an approval somewhere that shed was approved somewhere. If not, doesn't matter if the prior owner put it in or 3 owners before. Unfortunately, in code enforcement, when people are cited, they're responsible for what's on the property, regardless of how it got there. Is it fair? Is that correct? It's not. That is the system, I can tell you, everywhere. As for the slab, yeah, I mean, when you're paving, you need a permit. So that, to me, that is, I understand you didn't know, and I respect that, but to me, that's much less than the shed. That's a pretty common thing. So I did note your letter, I read it, I understand how you feel, I understand you've been there 20 years, but it doesn't change the fact that these are violations. You're gonna have 30 days to comply, which means you've gotta look, maybe contact who you bought this property from. Take some time and go into the town building department records and see if there's a plan showing the shed that was approved. That's the end of the shed, then you're fine. If not, you're gonna need a permit for that shed. How long does it take to get the shed permit? That could be very quick.
Right, shed permits is structural and zoning review, and worst case scenario, it would probably take 2 weeks to review. More or less, it takes 3 or 4 days.
Well, I'll tell you, because you're unlike these other properties, you're a single-family homeowner, and, you're not a commercial property owner. I'm gonna give you 45 days to comply. So you're gonna have a month and a half, but you're gonna need a month and a half to figure out that that shed is permitted by showing the town and proving it, or you're gonna need a shed permit, and I think that getting the asphalt, the paving permitted should be much simpler. I mean, you're probably halfway there with that, all right? So that's what the order is gonna provide. There is a violation of these 2 sections. I think that's been proven. I've heard you, I've heard your testimony, but there is a violation. You're gonna have 45 days from today's date to get those permits or to prove that the shed was permitted. If not, it's gonna be a $50 per day fine. There's a $100 fee for every single case here, and that's what the order provides. I thank you for coming in. I'm sorry I did listen to you. If you want to remain a minute, you can get a copy of the order of rental will be mailed to you.
Okay. Okay. Page number 3, item 10,
5518.
5510. It's on page number 3. Chief Code Enforcement Officer Jocelyn Ramirez, case 5510, site address 3711, Southwest 52nd Avenue, property owner Pembroke Park Holdings, Inc. A notice violation was issued on January 11, 2021, and was sent out regular mail. A notice of formal hearing with the notice of violation was sent out certified mail on May 3rd, 2021, and posted on May 7th, 2021. There are pictures on the record that depict the violation on January 5th, 2021. And a reinspection on May 7th, 2021. Okay, okay. Okay, right now what is pending is an unpermitted shed. The owner has to obtain plans, permit, and inspections, or either to legalize it or to remove it. That is the only outstanding item at this time. There was an unpermitted awning from the tenant. I mean, it wasn't a very sound structure awning, but they removed it. There was covered on the windows. They removed those. Overgrown trees, overgrown vines were all trimmed all over the perimeters. Trash nuisance, all the trash has been removed. Prohibited outdoor storage, that has been removed. And the addresses are visible to the property. And a damaged chain link fence was repaired, so that has been complied as well. So the only thing outstanding is the permit for that shed. Yes.
The shed was removed, huh?
Yes, but you need a permit.
I understand.
Okay.
What are you recommending?
30 days and then I'll do it for you.
I'm recommending 30 days. And if not, a per diem of $50.
David Horowitz, and it's 3715 Southwest 52nd Avenue in Pembroke Park, and I am the victim. Owner. No, I'm glad I'm here. She knows me, and I comply always. I do not discuss. Is it true or not? Did I ever?
Yeah.
Yeah.
He
That's it?
complied.
I just need a week, and that's it, and we're done.
All right, well, we're gonna do a little bit better than a week. I'm clear with compliance, so there is a violation of the unpermitted shed.
It was removed. The shed is not there.
Is removed without a permit. The building department says for any structure they have to obtain a permit for removal.
Well, I didn't know that. The problem was there was no electrical connection, there was no water connection. It was a freestanding piece 4x4, which the tenant took it in his truck and he gave it away to somebody else. I don't know.
I understand, but that's an interesting technical point to me. I've heard many cases of the need for a shed to be permitted.
To remove. To install is one thing.
Please don't interrupt me.
Thank you. I'm sorry.
Many cases about how sheds need to be permitted for removal of sheds. I don't believe a permit is required clearly by the town code,
Well, the Florida Building Code.
the Florida Building Code.
Yes, I confirmed this before proceeding with the case. I confirmed this with the building department, the building manager. And, you know, I did explain it as Mr. Horowitz explained it. There's no electrical or water, and they still required a permit.
In fact, I just, I don't wanna, deliberate too much, but the fact that the shed has been removed and is no longer there, can a permit still be issued after the fact?
Yes,
Like any
and
other
after the fact permit.
Okay, I understand. Sir, what you need to do is know the permit, is for a removal that has already occurred. This is what's known as an after-the-fact permit. So I am gonna note in the order that the sole open violation at this time is a, building code permit which is required for removal of the shed. So that's what's known as an after-the-fact permit, as you well know. So you're gonna be given 30 days to obtain that. If not, there will be a $50 per diem fine. And there is the $100 prescribed administrative fee for every hearing. And that's what the order provides. And I have made the note on it that because all your other violations were corrected, this is the sole violation today. If you want to remain a moment, you can get a copy of the order, and if not, it will be mailed to you.
Thank you. Thank you, Joseph.
Okay, just hang on. We still have one more case. May we continue to the next case, which is the same property owner? Okay, it's on page number 3, item number 16, case 5712. Chief Code Enforcement Officer Jocelyn Ramirez, case 5712, site address 3715 Southwest 52nd Avenue, property owner Pembroke Park Holdings, Inc. A notice of violation was issued on March 30, 2021, and given out by regular mail. A notice of formal hearing with a copy of the notice of violation was given by certified mail on May 3rd, 2021, and posted to the property on May 7th, 2021. There are pictures that depict the time of the violation on March 29, 2021. And a reinspection on May 7th, 2021. Okay. Okay. But at the time of the reinspection, there was, well, at the time of the violation, it was noted that there was awnings, water heater, electrical, wooden enclosure, and a semi-truck parked in the swale. All these items, I'm sorry, let me repeat this again. Awnings, water heater, electrical for a washer and dryer, a wooden enclosure were done without permits. And those are still outstanding. There's still no permits in the system for those. The semi-truck that was parked in the swale has been removed, so that's been complied with.
We have certain
No.
It's a water heater. Electrical for the washer and dryer.
Electrical for the water.
And a wooden enclosure for the washer and dryer. We're done without permits.
And what are you recommending on this?
Before you recommend, it was removed, for you to know. There's no washer, no dryer, no wood, nothing.
No, we said the electrical for the washer and dryer.
No stomach. Remove it. They don't have.
Okay, sir, again, we're discussing that you can't remove anything. If you remove something, now you have to get an after-the-fact permit. So you either do it, start anything
Okay.
that you're gonna do with a permit or not.
Sorry.
I'm recommending 30 days, and since this is a repeat violation, $100 per diem.
$100 per diem for what? After the 30 days?
After the 30 days.
Okay.
And you can always come back if you need more time than 30
Okay.
days.
I'm going to find that there is a violation based on the testimony and the evidence and the reports of record, which I hereby adopt. For the lack of a permit, I'm also going to find that under Chapter 7 of the Town Code, this is a repeat violation and that there has been the same violation.
Which is the repeat
By the
violation?
same owner, that has occurred within the past 5 years. So this order is going to provide for compliance within 30 days. If not, the per diem will be $100 per day. And, of course, the stipulated administrative fee,
$100.
$100 for each hearing. And that's going to be due if there hasn't been compliance with all permits as needed for the water, the dryer, the washer, the enclosure, anything you need removal permits for within 30 days after the fact permits. And if you want to wait a minute, you'll get the order.
I'm missing one. I won the lottery. I have one more.
You have one more.
Yeah.
No, that one has been complied.
Okay.
Case 5509, we announced it in the beginning of the hearing, that everything
didn't
has been
know.
complied on that one.
I wasn't here.
Okay.
5 what?
5509.
Okay. Thank you very much. Yes.
Copy of the orders.
Thank you. Thank you, Jasmine.
Okay, may we continue, Your Honor? Okay. All right, page number 3. Item number 12.
5545.
Correct.
Polo Club.
Yes. Chief Code Enforcement Officer Jocelyn Ramirez, case 5545, site address 5590, West Hallandale Beach Boulevard, property owner DREWBOYINC, the Polo Club Inc. The notice of violation was issued on February 19, 2021. It was given by hand to the contractors and delivered by regular mail. A notice formal hearing with a copy of the notice violation was given by certified mail. on May 5th, 2021, and posted to the property on May 10th, 2021. There are pictures enter into the record that depict the violation on February 19, 2021. And a re-inspection on May 10, 2021. The violation was it was a stop work order. The Red Apple roofing contractors started to repair the roof without a permit. So they need to obtain plans, permit, and inspections. At this current time, there is a permit application, and the permit is ready to issue. Not sure if the contractors have come and pick it up, but the last I've heard from the building department is that they have to pay the fee and obtain the permit, pick up the permit. No. No.
They got the permit. They're actually starting.
They picked up the permit?
Yeah.
Okay. So they picked up the permit, so they would just have to go through the scope of work and complete all inspections. So complete the permit. I'm going to recommend 30 days, if not a $50 per diem. Unless the owner is requesting more time.
30 days for what?
To complete the permit.
Okay. Well, they started today.
All
so-
inspections and everything.
Okay. So at this point, I don't have any fine or violation until...
I'm sorry, can you state your name for the record?
My name is Andrew Reed. Oh, okay. Excuse me, sir. Andrew Reed, 5590 West Hollandale Beach Boulevard. Good morning. No, I was asking the 30 days to basically complete the project, is what you're saying? And get
Yes,
the permit
complete the
signed off
permit.
on. Okay. Yeah, the permit was hung up for almost a month. I think, Jeff, you're aware of back and forth with the contractor and so forth, so. Any rate, at this point, it's in process. The permit's issued and the work's being done.
Well, then, I get here based on the testimony and the evidence and the other butter testimony that there was a contribution work being done on the permit. I appreciate you coming in and speaking. I'm glad that the owner is underway in complying with this. So the order is going to find that there's a violation because that's been clearly proven. You're going to have 30 days to close out the permit, comply with it fully so you can have it closed. You understand what I'm saying?
Understood.
I'm sure you do. And if not, there will be a $50 per day fine, and of course, the $100 administrative fee for each case hereby imposed. That's what the order so provides, and you want to remain here a minute, you can get a copy of the order in order to be known.
So the $100 administrative cost is imposed for what happened already, is that correct?
Every case that, if you ask, every case that, there's a cost to the proceeding, everything you see.
Understood.
Every case, and this is the same every local agency, there's some kind of fee for the hearing.
I got you, yeah.
So that fee is imposed in every case.
Okay,
And you have to pay it within 30 days.
not a problem.
All right? And the fine you'll have to pay if you don't comply.
Understood. Thank you.
Okay, and Mr. Reed, we do have another case for him, so I would like to continue with that one.
Yes, what is that one, starting with the number, all that?
Okay, this is page number 3. It begins on on the hearing to abate fine section, which is number 9, and then the first item.
Oh, the hearing to debate fine.
Yeah.
It's 4578, right?
Yes.
4578.
Now, I would go ahead, I would like you to explain the procedural.
Right, I will.
Okay. Okay, I'm sorry.
Is there an order for that?
There should be an order, an abatement order for that, but I'd like to explain what's going on with the case.
All right, yes, please. Case 4578, DREWBOYINC.
Yes. Chief Code Enforcement Officer Jocelyn Ramirez, case number 4578, site address 5590 West Hallandale Beach Boulevard, property owner DREWBOY Inc., the Polo Club Inc. So this matter is for a rehearing of an abatement of fine. The previous special magistrate did abate the fines that accrue. I'm sorry, would you like me to state that we sent out the certified and the posting, or at this point? Okay. Right.
And normally, an order of abatement certificate is otherwise, but if somebody has to comply, the violator, or do something within a certain time, the fine can be paid, and if not, the fine reverts to what it was originally.
Correct.
So what is the posture here?
Okay. So the fine had accrued from September 1st, 2019 to February 4th, 2020. And that was $100 per diem, and it accrued for 156 days with an administrative fee of $100. The total amount was $15,700. The previous special magistrate on the hearing of April 13, 2021, abated the fine to $7,900. So this matter is at a rehearing because the property owner requested that he missed the first hearing, so he wasn't able to discuss it with the special magistrate. So we're having a rehearing to discuss this abatement order that already has been in place.
Well, town council was here and so forth, and but again, I tend to be somewhat traditional in these kind of things,
He asked for a rehearing, so that's why we're here. We're giving him that.
Right. To me, unless the code provides, there was already a rehearing for whatever reason. I'm sorry you missed it. There was an order entered. I would even query how there can be a rehearing from a mitigation order unless the code provides for it, frankly. So, to me, there's nothing to do here. Other magistrate who's ruled on the matter, and I have to respect that, has entered an order, and he mitigated the fine to something like half, which is what typically is done.
I think less than half.
Less than half, actually. So
Yeah,
that order.
it actually was half, as you mentioned.
I don't know what you want to, so unless you have something really compelling to say.
Well, I do.
What is it? Were you notified of the first hearing?
Which
No,
first hearing?
Were you notified of the first
Which,
hearing?
which hearing are we talking about?
Of the hearing to abate fine.
April 13th.
Oh, I was not notified directly. I was shot a screenshot of it by a person that was giving the order to. I was driving, I read it, I thought it said the 16th, and it was actually the 13th. So I'm preparing for a Friday hearing, which apparently you guys don't do that. That's why I was not here. There's a real, issue going on.
But it was correctly noticed. It was correct.
I did not, all right, here's the issue. There's an ongoing issue. Officer Ramirez is very familiar with this, of me receiving notices. On this particular offense, I personally received nothing until after the fact I got a bill from Michelle. That was the first time I was even aware of this ongoing per diem with the vehicles. I have a warehouse that is my mailing address because I don't want to have my personal address on public record.
Officer Ramirez did acknowledge that mail was being returned, and also that the address is wrong on the Broward County property appraiser's information, okay? To this day, I'm not getting proper
Well,
delivery.
Let me respond to that. Town and the cities go by the address on file with the property appraiser's office. That is standard, that is the norm, that is the prevailing practice. So unless there's another address that you had on file here in the town, for them to send something to you, that is adequate.
They do have my other address. That's how they
Well,
communicate with me.
And more importantly, from the town's point of view, and I would like to get this on record, that's what's provided in the statute.
Mhm.
So, with all due respect, I mean, got notice by proper notification of the statute. You did get some relief under the abatement.
But the issue is, had I known, okay,
Or by your
let-
own
can
decision.
can we backtrack a little bit, sir?
Your motion,
Your Honor?
Your motion, your reconsideration respectfully is denied because you knew of the earlier hearing, you acknowledge that, I appreciate you.
I did not acknowledge it. I didn't even receive it.
You said you saw it.
I saw a screenshot of it. It was very difficult to read.
That's, respectfully, what you failed to do is not the town's problem.
The problem is,
That's not due diligence.
that here, this is the problem that I have an issue with, sir. And Your Honor, and everybody here, with all due respect, I own multiple businesses between Miramar and Pembroke Park. In the past, JT was the code enforcement officer. He would call me if he had an issue before it reached this type of level here. Miramar does the same exact thing. I am under the assumption that they would continue to operate in that manner. If why would, I even asked Officer Ramirez, why would you not communicate with me when you have my email address, my telephone number, and other ways to communicate when you talk about $100 a day per diem? She said, I thought you were being defiant. That's not part of my nature to be defiant. I'm a business owner. I'm very proactive. I had an accident on about 10 accidents that's wrecked my property multiple times. The last one, she sent me a notice. Within 2 or 3 weeks, I put in the ficus hedge. It cost me almost $4,000 to put that in. I put in an insurance claim. Happens to be the city, the town of Pembroke Park, also has an insurance claim for the same accident that is coming in front of mine. Now, I know that's not relevant to this case, but my issue is lack of communication. With this type of numbers, $14,000, I'm struggling from COVID. I have termite infestation. I have a roof to repair. I want to paint my building. The town of Pembroke Park is very concerned with aesthetics, and I am too. I come from a good background. I do landscaping. I do painting. I do all kinds of stuff that I do to uplift properties that I own. And if they were concerned with the aesthetics of having a couple cars in my parking lot, they could have contacted me. And that she's aware that there was a problem with the mailing.
I cannot, all I can tell you is, I do try to be fair, I do try to be equitable, and I listen to everyone, but I also try to be uniform and impartial and follow the rules. So, as to the fines, nobody likes the fines. I can tell you for what it's worth, that in this town, $100 is somewhat modest.
$100 is modest. $7,900 is not modest.
There are many other jurisdictions, sir, that have $250 a day and $500 a day. I can tell you, okay? So $100 a day is somewhat modest.
This is something that happened in 2019. The minute I found out about this issue, I got the cars removed.
Most importantly, you made a motion for fine to be abated. Heard by the magistrate, whether he should have heard it or not, the fact is you were noticed, it was noticed per the law, that's been established.
It wasn't delivered to me by law.
What I mean is that they sent
It was given to somebody else. It wasn't even given to me. I've never met Officer Ramirez.
With all due respect, Your Honor, you had notice. You had statutory notice. You knew this was going on. And you had, apparently you had notice on your phone, which you didn't bother to look at correctly, and you showed up 3 days later. You got it cut in half.
That doesn't solve the underlying issue is communication here. I am being crippled financially.
Sir, respect.
Who are you,
I am
ma'am?
the town attorney.
Ma'am, who are
I am
you?
the town attorney,
Ma'am,
okay?
okay.
And I am telling you right now that they are giving you a lot of respect, and they gave you notice per the statutes. And for you to sit here and to abuse them
I'm abusing them?
is ridiculous.
How am
to
I
say they
abusing
haven't
them?
given you notice and you need to be personally called. The reason that we have no new code enforcement staff is because code enforcement should not be personally calling property owners.
Well,
to
that's
tell
what you've
them
done in the
there's a
past.
hearing
That's
coming
what
up.
Pembroke Park has done in the past, and that's what I'm used
I don't care what
to.
they've done in the past. This is Pembroke Park. We gave you statutory notice. You got over half your fine abated. I'm
The
stating
fine
this
is
all
absurd to
for
begin
record.
with.
If you
That is
want
my
to
contention.
appeal. But don't waste our time here today complaining that you didn't get proper notice. That's disingenuous and not fair to the
It's not
town staff.
disingenuous, ma'am.
Yes, it is.
That's your opinion.
No,
My
that's-
opinion is,
no.
this is
Sir,
a money-making
that is not my
situation that you guys are
opinion.
making.
Please, let me, look, sir, I appreciate.
I didn't come here and expect this from you people. I thought this was going to be a decent
We are.
proceeding.
And I appreciate you coming in. And the fact is just this. I am listening to you like I would any other person. Unless you came here, just so you know, and said, my mother was in the hospital, I was in Brazil, I appreciate your honesty. I respect.
I could have made up I'm not a liar. I could have made up a
No, I
story.
agree, and that's what this is, that's what the law is all about. Because if you'd be lying, you'd
If
be
I,
subject to a personal
if I got the paper in my hand, I just could have read it.
No, I understand, but you were noticed, they noticed you per the statute, and I appreciate your honesty, but you misread the phone screenshot, that happens, but the fact is, you were noticed. There was a hearing, the other magistrate, I have to respect these other people, they're hearing officers, he held the proceeding, he reduced your fine to less than 50%, and I think that under these circumstances, there's nothing else for me to do.
That's financially crippling
So
me.
listen, I don't want to continue a recurring narrative about it.
How do I appeal this? How can I appeal this?
There is no action taken today. I am not taking any action on it. So I don't know what you want to appeal. Consult with a lawyer. I can't advise you on that. I'm sorry. Okay?
If I'd known I was going to come here to find that this couldn't even be considered, I wouldn't be wasting my time either.
Sir, it was considered by another magistrate in Wilbur Park. Thank you. Okay, you can't keep going back to court when you don't like a result. Thank you. Next. I will tell you because I like to do everything on the record. I will tell you, I understand things are hard. But it's worth my own opinion. I'm not addressing this to him, but in general, there's nothing in the code that provides for it.
Okay.
All
For
right.
future, we will note that.
I agree.
Great. Perfect. Okay, we'll proceed to the next case. Page 4, number 2, case number 4837.
Eight, four,
4837.
four, eight,
Correct.
4, 8, got it.
Morning.
Okay. Code enforcement officer. Jeffrey Lewis, code enforcement officer for the town of Pembroke Park. Oh, okay. 4837, yeah.
Did you submit an order for that?
Yes, it shouldn't be in the folder, it should be.
Where is it then? Can you tell us where the other? Your orders will need to be submitted.
On behalf for
I'm sorry, I don't know how this was, I apologize, I don't know what this was even doing here. Maybe my mistake.
Okay, great.
All
Don't worry.
Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park, case number 4837, which is for Janet Castellanos, located at 414 Lone Pine Lane. This is in reference to a notice of violation that was written overview. This is in relation to a notice of violation that was written on January 7, 2020. A notice of formal hearing was sent out on May 5th, 2021, and the posting of the affidavit of service was on May 10th, 2021 as well. The notice of violation is for work done without a permit. This is in relation to addition to mobile home, shed, door, window, deck, and awning, all done completed without a permit. And then the other section is verifying the number of occupancy for a mobile home. That is.
Explain that violation to me.
Okay. Section 28-272 of our zoning ordinance requires that mobile homes are single-family residency. They cannot be split or rented out with multiple. So this is to verify that it's a single-family occupancy and not being used for rental or anything additional. There was no access into the actual property at the time to verify that, and that's why it was added as a condition. In regards to Section 5-105, repairs and installation, which is no permit for, like I mentioned, the addition and everything else. The property owner has come into the building department and spoken with myself several times throughout the year in regards to what needed to be completed and how to obtain permits. And the last conversation is that they were trying to reach their engineer to develop plans to submit into the building department. And that has not been completed as of yet.
And what do you, so here we have the basically unlawful, unpermitted addition, and the occupancy thing, which means that you're avoid, a mobile home being turned into a rooming house.
Correct.
So those two things are still outstanding. What are your recommendations?
The recommendation is to give 30 days to apply and obtain their building permit to complete the construction of the deck and to legalize the additions. Otherwise, it would be $50 per diem and a $100 administrative fee for the case. The respondent has also mentioned that the occupancy is for another person of their household that's using the addition, but that has not been verified as of yet.
Someone that is related by blood or marriage.
Correct.
All right.
I believe there's
Has the
some.
burden of demonstrating that to the town. We are just saying so. Anything else?
That is all.
Ma'am, you are start to drive us to the relationship to the property and then we will.
Hi, my name is Salome Gonzalez. I am the owner with my mom, Janet. I live alone with my mom. I don't have anybody to rent the space. When I bought, I already had all violation. I didn't know. I asked into the manager, and she said, well, was 20 years ago, around 20 years ago. I have maybe another administration. I spoke with the previous owner and said, well, anybody asking for permit, anybody asking for any paper, no city, no administration. It's completely new for me, all issues.
How long have you lived there, do you think?
I'm sorry?
How long have you lived there?
4 years. 4 years.
4 years. So, you know, the fact is, as you may have heard, if there's violations, doesn't matter when they happen. If it's your property,
Yeah, I know.
you're responsible. So, you understand what the city wants? The thing about this other person, she said it's just her mother. So if it's just your mother, you just need to demonstrate to the city, I'm sure you have a 50 documents that can do it with that person is your mother.
I had a child under my mom's name. I bought, but I live with my mom.
Right.
I live along with my mom. Anybody live with you?
What they can,
You know, she's saying she lives with her mother, so I don't know.
what they can do is we can set up an appointment to view the addition and just to verify that it's not being split off into different sections for rental or anything else. If that's the case and everything is clear, then we can show that that's in compliance to show that it's a single-family residence.
So what that means is they're not gonna come running to you. You have to go to them, make an appointment. They have to come and do a home inspection. They have to verify that you have not subdivided your mobile home in order to rent or lease or license it to other people, which is illegal.
Yeah, I know.
You understand?
Yeah.
All right. You need to do that right away. As for the addition,
In order to comply with the addition, they can do one of two things. Either have architect or engineer set of plans to legalize the addition, or they would need a permit to remove the addition. It's up to them what they would like to do.
Again, there seems to be different groups. There's a group here of like commercial investment type of people. This seems like a single-family homeowner kind of person. What is a reasonable period of time to? I mean, they don't seem like entrepreneurs.
How much time do you think that you would need to correct the violation?
Okay, I already looking for somebody to fix that, a contractor. She left out of the country. She never answered my my calls, my emails. I contacted somebody else, and he said to me this morning, it's supposed she come back next Thursday because I already paid to her. And I, when I told to you,
You should never pay for work in advance.
I'm sorry,
You should never pay for work in advance.
$3,000. And but when I spoke with Jeffrey, he told to me that she hadn't completed the application. All my information is wrong.
Right, this has been going back and forth for over a year now, and needed to submit plans to show the addition and have it taken care of. And like I said last I spoke, she was trying to get a hold of her engineer in order to have all the documents ready to submit.
You need to get a new engineer, you know, I mean, I don't know, you know, I understand that everybody, it's a burden on this, but the town is just, you know, put it this way, I think when there's a mobile home, you can see something that you get out of benefit, is that you pay much less than real estate tax.
Yeah.
So you're gonna need to comply with this. You're gonna need to demonstrate that you haven't subdivided that to rent to people, and the town's gonna have to confirm it. And these additions, doesn't matter when they were done, they're yours now.
Yeah.
Either need to be approved, or they need to be removed. You're gonna need permits.
Yeah, the problem I thought with a lot of people is too expensive. It's more, the money is more that I pay for the mobile home. It's ridiculous. Because 8,000, 60,000 to fix that is what? It's crazy.
What is a
Right there.
reasonable period of time?
Would 45 days additional time would be okay?
Okay.
We can enter 45 days.
I'm gonna find
Because a month and a half.
violations here of the fact that you simply have to have the town verify, as required by the town code, that you and just a member of your family are living there and not other renters. And two, your additions need to be either permitted by the town or removed with permits. If you saw the other case with the man, you can't just remove things, you need a permit for removal as well. You're gonna have 45 days to do this. If not, there will be a $50 per day fine.
After 65 days?
After
45?
45 days.
Okay.
After 4, 5 days. On the 46th day, it will be $50 a day until you correct this.
Okay.
So you better correct it within the next month and a half. In addition, there's a $100 cost of the hearings, which is for all cases. All right, I appreciate you coming in. I'm sorry about this, but this is what the evidence and the documents approve. If you want to stay a minute, you can get a copy of this order.
Okay.
Or the city will mail, the town will mail it to you. You want to stay a minute? You want to stay and get a copy of this?
Yes, please.
All right.
Thank you.
The next case is going to be on page 4, number 7, case number 5297.
Wait a minute. I just found it. I found it.
Correct, 5297. Good.
Good morning.
Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park, case number 5297. Gerald Anderson, also A&B Recycling, located at 1708 Southwest 31st Ave in Pembroke Park. This is in regards to a notice of violation for maintenance, exterior maintenance of the property. And we have photos to enter into the system. Okay.
Teresa?
Yeah. Okay. The initial violation was written in July 30th, 20. Oh. Five two nine seven. You could go down to the photos. Yep. The initial violation was sent via mail on July 30th, 2020. And the affidavit of service was done on May 10th, 2021. And the certified mail was completed as of May 5th, 2021 as well, with a reinspection of 5/10/2021. The notice of violation is in regards to exterior maintenance, which is banner on this banner sign on back of the wall. The banner is prohibited and needs to be removed. Exterior wall needs paint on north and west side of building. Damaged fence in front of property. The fence will need to be replaced. A permit will be required to repair and replace the fence. Sign maintenance on the north wall. There's graffiti on the signs that needs to be cleaned and taken care of. And overgrown vegetation in front of the property.
Which of these, the damaged fence, repair, fence, graffiti, overgrown vegetation, which of these, are these all still out of compliance?
At this current time, all of this is still out of compliance, and it would need to be in compliance. Recommendation would be 15 days. And since this is a repeat violation from a formal hearing of case number 4400, in which...
Is that the case number?
Correct. Case number 4400 was the prior hearing in which a final order was recorded. So this is considered a repeat violation and recommending 15 days or $250 per diem until the violation is corrected. No, not at this current time.
So this is your testimony, and the record is that in case number 4400, it was the same violation of the same code by this violator within the past 5 years, and that is why you're requesting 15 days and $250 per day.
Correct. The previous case was also with the debris that was on the town's right-of-way, and that was completed as well, in which I believe there's another case for that as well. But for exterior maintenance, that was completed on the previous case as well.
So again, it was the same, per your
Yes.
testimony, same violation.
Same ordinance, same violation in the past 5 years, yes.
All right. Sir, your name, your address, and what do you want to tell us?
Gerald Anderson, owner. Okay. Wall's been painted a couple weeks ago. Sign's been done a couple weeks ago. The fence is being repaired, but the guy got sick. He has COVID. He started it, and I think you can verify that from what it was and what it is now. And he did start it, but he didn't finish it. I spoke to him this week. He says a couple weeks. I didn't know this was going on either from July. I don't know from July, but I know in January you told me about it. So, but other than that, everything is legit. I painted the wall. I trim the trees every 90 days. The fence is half repaired. That's pretty much it, right?
The sign on the back of the
Sign's
property,
been
was that
done.
removed?
That was the neighbor's sign. I had that's been removed. It wasn't my sign, but that was the panda sign.
That's been? Okay, great.
Long time.
Okay, so the sign is in compliance. So the
Sign is in compliance. You're about the graffiti.
I don't think there was no graffiti.
There was graffiti on the sign of A and B on the
Okay,
west
we
end.
we did that. We did that. We had the sign cleaned, pressure cleaned. First, I pressure cleaned the, first we pressure cleaned the wall and everything, and then didn't work too good, so then we painted the wall, and we cleaned the graffiti off the sign. That was clean as well.
Yeah.
For the entire.
No, everything's,
Then the last outstanding item would be the fence that needs to be repaired.
So, as to the testimony that you heard from him, and has that impacted your recommendation?
No, it'll still be the same recommendation of 15 days. And a repeat violation of 250.
Because this man has been again, no offense, not the person who has been a referring owner, and because based on the photographic evidence and the testimony, I realize there was recycling business, but the photos show this to be something that's supposed to be so the order is going to provide that you need to comply, and I want you to be clear on what is outstanding, which is fence repair, the overgrown vegetation,
Mhm.
and is there anything else?
No, the others have been complied with.
Because of your history of these violations in the town, you have 15 days to do that repair, and if not, again, because of your prior violations, sadly, it's $250 a day. If you have not complied within 15 days. Am I clear, Mr. Anderson?
yes, sir.
There's
Now,
a $100 administrative fee that is imposed on everything
All right.
as well.
To be clear, in the notice, it was also for the fence to be repaired, may require building permits.
Okay, I
So you
wasn't
know-
aware of that, because we just was, a car hit that fence. I found out anyway, but it was repairing it. We're gonna use the
Right,
same.
you may
just
want to
pull
double
it
check
back and
with the
repair it.
building department to see if it is requiring a permit to repair that fence.
All right.
If it is required, you will need to pull the permit to repair the fence. If it is not required, then you can go ahead and just repair the fence.
Sounds good.
I think at this point, that fence is severely damaged. Is holding on his last limbs. So just
Okay.
I agree
pull a
with that.
permit
It's-
and put in a new one.
It would be recommended to speak with the building department to,
All right, all right, yes, sir.
Now, Mr. Anderson, wait a minute, because you will be given the order.
Well, he can stay there because we have another case for him to be
Oh.
heard. It's case, all right, let me
What other
find.
case is that?
that's your case.
It's page number 3, item number 17.
Page number 3, item number 17, and
Case 5523.
5523. 5523.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 5523, site address 1708 Southwest 31st Avenue, property owner Gerald Anderson, business A&B Recycling. The initial notice of violation was given on February 3rd, 2021, sent out by certified mail. On February 4th, 2021. And a notice of formal hearing The copy of the notice of violation was sent out on May 3rd, 2021. Posted on May 10th, 2021. The violations, there's pictures that depict the time of the violation on January 27, 2021. And a reinspection on May 10, 2021. Currently, this violation was for the accumulation of scrap metals and hazardous materials causing spillovers onto other businesses and Towns Row. Property owner must clear all scrap metals, hazardous materials, and other materials from Towns Row immediately. That is not in compliance, and the property owner is still currently using Towns Row for business operation. Right away, yeah. Business owners is using Towns right away and public parking area to unload and reload scrap metal and materials. Business owner is only allowed to operate within 1708 Southwest 31st Avenue. There's also overgrown vegetation, as stated earlier, and dirt buildup around the area that's been, the area where town right-of-way is, there's a buildup of dirt that needs to be maintenance by the property owner. It needs to be pressure washed. And then I also included in this violation that if the owner fails to correct any of the violations, then the town will remedy the situation, will clean up at the owner's expense. I'm recommending that all these violations be taken care of within 10 days. And since it is a repeat violation, a 250 per diem, if not corrected within 10 days.
For your testimony, this same violator violated same sections of the town code within the past 5 years.
Correct.
So here, what do you want to say, again, for the record, Mr. Anderson, your name, your address, and what do you want to say about these violations?
Well, we pressure clean. I don't know where the dirt buildup is at. I don't know.
Once you remove
we
everything,
pressure cleaned it already.
once you remove everything from Towns Row, which is your property line is where the fence is. You're operating outside of that. You have vehicles, you have storing there. That's all prohibited. You cannot use that area to operate.
That's right away. That belongs to the town.
Okay, like there's, but I'm saying there's only a little, no, there's only a little concrete, I want to say, that's in the driveways that we can pressure clean. The rest of that is dirt. Like here's dirt. The driveway is concrete, so I pressure clean wherever there's concrete.
I think the main concern is to remove everything, have it cleared up, and after everything's cleared up, of course, we're going to see more of the buildup, and it has to be maintained.
Okay. I mean, and it doesn't look like that, huh?
Everything has to be within,
Yeah.
that's a reinspection from May 10, 2021. We're at the 18th.
Okay.
And the landscape has to be maintenance periodically.
Yeah, I do that every 3 months. I get the trees done every 3 months. So that's being done every 3 months.
I understand that I'm going to find your repeat violation based on the record, based on the town code that's already read into the record that I've been notice of, and it's 250 days. What did you tell me, and I apologize if you told me this, but what did you tell me in writing, the nature of these violations was the recommended time?
10 days.
10 days? I'm gonna go with 15 only because we've already had a series of different dates, and I don't like to be,
Okay, that's fine.
I'm gonna go within 15 days, and it's going to be, $250 if you haven't complied within 15 days, because you are a repeat violator. And I am also going to provide, because I don't see it here in the order, so I'm going to annotate it personally that, per the town code, as applicable, and Florida statutes, town may perform needed corrective work.
Yes, it's on the town code. Oh, in the order, the section should be there. It's 12-42, 12-46.
Oh, okay, all right, thank you, okay. What I
Sorry.
did was not provided for that.
It's written on the notice violation is detailed on the notice of violation.
I understand what you're saying, and again, not to engage in, all I'm trying to articulate is that
Mhm.
it's written in terms of you have a violation, you have to correct it within such time, but not in terms of explaining the town may take corrective action, which I think is a preferable practice, to say it here.
Okay.
However brief.
Sounds good.
May perform the needed corrective work and, impose charges and means what it's costing you. That's all I have to say. Yes, I understand what you're saying. It's represent- That's good. I just like to spell out that sentence. So this is what the order is gonna provide, sir, and, I entered it, and you can remain a moment.
I have a question.
Yes, go ahead.
If I need to get a permit, then that gonna have to wait for the permit. So that's gonna need more than 15 days to do the fence.
Well, let's,
If we want to,
this
the other
case,
thing I want to say, if you
case
willing to-
5523, the order has been made, so he has a question regarding case what?
Oh, it's both. It's
5297.
they're connected. The same. There's two.
They're
two
not
things that are
connected.
The same thing.
They're not
So,
connected because mine had no mention about the fence. Mine had
But
mention of the
that's what it,
materials you have outside of the fence
okay.
have to be removed.
Okay.
Previous case is under mine, which is exterior maintenance, which includes the fence. That order has already been done of 15 days. Once it's
Okay,
been
but
completed.
then afterward, you told me that maybe I need to get a permit. Maybe I don't. But if we do, it may take more than 15 days because you're gonna have to wait for the permit, right? Is that the correct procedure? Because I really don't know.
Are you saying?
Do
you
you
need
start,
more
do you,
time?
because he already started it. He already started it. But if we need to go get a permit, and I'm kind of trying to talk for somebody who's doing the job, but if you need to get a permit, they need a permit, then you need to finish. So then at 15 days, I don't think gonna be enough. But I think, well,
So how much time are you requesting for that one?
I always wanted to ask, could you do this? You evaluate it, he's going along, if it's needed more, you give me a little bit more time. If it's not needed, then we don't need it.
Then you will request a hearing to extend time.
I'm sorry?
You have to request a hearing to extend time. Is that correct, Your Honor?
No, I
You
didn't.
put a greater time than the 15 days in here now. You would have to request, and you would have to schedule and have heard a hearing too.
I mean, if you see, like, it's going along, he got the poles, or he got this, and you wait for the permit, and it's going along, and if you needed a few more days,
You want to change.
do you do have to go back and get a hearing?
I'm not telling you what to do, but you're right to do it.
Correct. We can keep it at 15 days, and if it shows that you're running out of that time, you can request a time extension,
All right,
and
that's what I'm
which can
saying.
be approved by the special magistrate for that additional
Okay,
time.
without a hearing.
At another hearing, correct.
What's the hearing? Yeah, at another hearing.
At another special magistrate hearing, as the
This-
same thing
this-
that we have now.
Okay.
However, are you requesting additional time at this current time, or you want to wait until you see if you need additional?
You can wait to see if we need it. I mean, I'm already pushing to have it done because it's already been started.
15 days.
Well, yeah, that's what we did, that's what was ordered, that's what was.
Correct. Okay.
Right, wait for a copy of these orders. And, what else is left?
Okay, they have the copies there for you.
Okay.
Anybody else here for a
Thank you.
hearing?
Yes, one
Yes,
more
one
person.
more.
All right, well, let's take care of that, because I'd like to.
Officer Teresa Malcolm, case number 5553. The site address is 3120 West Hollandale Beach Boulevard, Lot 1010 in Pembroke Park. Owners LaSalle Gale. Initial violation was written on March 2nd, 2021. That was served by hand. Notice of formal hearing as well as a copy of the notice of violation was mailed on 4/29. Yes. All right. Affidavit of service and posting was done on 5/10, as well as a reinspection of the property. Originally, the notice of violation was for the stairs and sheds at her RV that was installed without a permit, to remove the miscellaneous loose items from her property, and also to remove the the washer and the dryer from the shed. Upon my reinspection on May 10th, 2021, Ms. Gale went ahead and removed the shed without obtaining the permit. The stairs are as is, assuming the washer and dryer was removed when she removed the shed.
So what is outstanding?
At this time, Ms. Gale will need to obtain an after-the-fact permit for the removal of the shed, as well as to get the stairs at her RV permitted, and to clean up the outside of her property with the loose items such as loose woods, pavers, miscellaneous items such as windows, etc. Needs to be.
The windows, you mean that windows as objects need to be removed? Is that what you mean, or is it the windows?
Sorry, there's pictures to it. I say windows. There's actually like windows part of her home. Great. Bear with us one moment. We'll show you the pictures. actual windows are not a part of her home that are out.
Windows that are just. the
Right,
window-
loose, yes.
The window structure, the window.
The frames,
on the frame or
right,
whatever is just there.
right.
um,
Loose on the
loose,
property, right.
Attached, it's not a fixture, it's just an item on the, yeah.
Right.
So that's, right, those need to be removed because they're not installed.
Correct.
What else? There is anything else?
Like her propane tank, it needs to be secured.
I'm
The propane tank, like when you go back to the picture, you go back, Jeffrey. I'm sorry, propane tank. No, propane.
Propane.
I'm sorry.
Okay. I understand. Go ahead.
Okay, the propane tank, she had a lot of miscellaneous pipes that were just loose on the floor. Originally in my initial visit to her property. And that was all.
So, freestanding, windows must be removed, propane tank, after the fact permit for shed removal.
Correct. And
removal of a few miscellaneous items that are.
right, and for her to obtain a permit for the stairs, to enter her RV. Mhm.
What are you recommending, officer?
I recommend 30 days, with $50 per diem if she doesn't comply by then.
Anything else at this time?
No.
Yes, hi, good morning. My name is Lacey. I live in that property. I just want to say that I have pictures here that we remove everything. Also, like she's saying, the shed, everything. We didn't know about that we need permission to put a shed. We asked for some contractor, but we couldn't afford because they asking too much money. The stairs is there because it's not there anymore. We took it ready also, but was there because I had accident with my baby when I was pregnant. I fell down and everything. That's why my husband put the stairs. So we remove it ready, and also.
You're saying you removed that?
Yes, we remove that. We remove everything is in the floor, whatever is in there, we clean it, we remove it.
All, those objects outside, I don't mean, things like windows, and you can't just have all those things just outside of a home. That's an eyesore, and on top of being an eyesore, it could be unsafe in the event of.
Yes, so.
Have you removed those things?
Yes.
But ma'am, for your reinspection, when was your reinspection?
On May 10th.
And that's a week ago. Yeah, it was still there. Those things were all still there. Madam Code Enforcement Officer,
Yes,
those things-
yes, I'm sorry, yes.
All right, look, what I'm gonna do is, I understand that you're, situation but you have to comply with those things in terms of, if, I don't wanna speak for the city, maybe the town will, speak clearer, but if you meet with them and, your loose items have been removed, the windows have been removed, but your propane tank will need to be permitted or removed, and if removed, you need a permit. You're gonna need to get a permit for the stairs, which you removed. So, in the shed, you're gonna need, if you heard from the other cases who were here, when you remove things, you need a permit for that too. So you're those things. And maybe if the town, I don't know if you can, what the town can offer her, but if you can prove that you did some of these things, maybe it will be easier for you, but you still need to, you just can't take out the shed and take out the stair, you need to get a permit for that. Is there anything else that
Like I'm saying, we couldn't afford to get that contractor. They're asking 700 and up. So we buy it and we put it we didn't know we're not doing that just because I need it and I put it. So like I'm saying, my husband installed the shed, but when I had the papers, the second day I moved the shed because like I'm saying, I can't afford to pay a contractor and it's still the same thing happening.
okay, you're in a certain situation, listen, I'm going to use my own latitude I'm going to give you 60 days to comply. But you have to fully comply with the 60 days, or there's going to be a $50 per day fine. And that means you need permits for all these things that were removed. And particularly now, again, it's beyond the scope of this hearing, but with the CARES Act, and the Coronavirus and the Relief Act and the American Family Assistance Act and like 3 or 4 acts coming out of Washington, many people are being sent, particularly people in reduced circumstances, are being sent government money. So I don't think that these things are particularly expensive for you to do. You're going to have, I'm going to take the latitude, I'm going to give you 60 days, okay? But if you have not complied in 60 days, that's going to be a $50 per day. And I'm only doing that, frankly, because of circumstances I see you in. So, all right, that's the order. You understand?
Yes.
Do you want to stay for a moment and get a copy of the order?
Yes.
So again, you have 50 days. That fine will start on 61st day. If you have not, all right? Now, at this point, does that conclude the hearings of persons?
Yes.
Okay, I'd like to just recess this for a moment. One, I'd like to just use the restroom, the boys' room, whatever you call it, momentarily. Then I'd like to, we can get right back on the record. I'll eat my lunch while we're doing this. We'll go through the other cases more quickly. Okay. All right?
Okay.
I'd like to recess for a moment. Where is it that,
Chalice?
No.
Is that one 5470 and then you jump to 5533?
You're right. Good. You already have the 5533? Okay, we'll start with that one.
yeah.
Okay. That's on page 3?
We're up and running?
Yep. Chief Code Enforcement Officer Jocelyn Ramirez. Case 5533. Site address 2400 Southwest 30th Avenue. Property owner 2400 Southwest 30 LLC. The initial violation was given on February 17, 2021 by regular mail. And a notice of formal hearing with a notice of violation was sent out by certified mail on...
Yes, a lady, I'm sorry, excuse me, I apologize. Kathy, some lady here gave me.
Okay, so you got them.
Yes, I got them, and I think that I can manage that there.
find them, I'll reprint them, just let me know. I'm gonna say goodbye, because I gotta call
Oh,
upstairs.
here, yeah, I have them, Thank you very much,
Awesome
and
job.
great
I'll
seeing
talk
you.
to you later,
Yeah,
okay?
okay, all right, thank
Thanks,
you.
guys.
Thank you, Madam City Attorney, thank you. Sorry about that, go ahead, yeah.
Okay. Certified mail was sent out May 5th, 2021. I'm sorry, April 29, 2021, and May 5th, 2021. It was posted on the property on May 10, 2021. There are pictures to enter into the record that depict the violation on February 2, 2021, and a reinspection on May 10, 2021. The violations were for paved and restriped parking lot without a permit and graffiti on the wall. Upon reinspection on May 10, 2021, both violations still exist. They have to pull the permit for the paved and restriped parking lot and remove the graffiti on the wall. No action has been done for this property.
What do you recommend on this case?
15 days to comply. If not, $100 per diem.
$1 per diem?
Mm-hmm.
Fine, and that, they will pay $1 per diem. Record that the respondent is.
Okay. I'm going to call the next one 5622 since it's a related property owner. Mm-hmm. Chief Code Enforcement Officer Jocelyn Ramirez, case 5622. Site address 2400 Southwest 30th Avenue. Property owner 2400 Southwest 30 LLC. Initial violation was given on March 11, 2021 by regular mail. And a notice of formal hearing with the violation was sent out on April 29, 2021 and May 5th, 2021. Posting was done on May 10th, 2021. There are pictures to enter into the record that depict the violation on March 11, 2021. And I'm sorry, this is particularly for unit, Bay C. This property is divided into 3 bays, Bay A, Bay B, and Bay C. This one is for Bay C. And there's a stop work order. The contractor started demolition work without a permit, demolition of electrical, structural, mechanical, plumbing without a permit. They continue work and they installed a new garage door without a permit. And they seal and patch walls where door or equipment existed without a permit. So all of these violations are still outstanding. They did try to pull a permit, but it has been fully denied in plan review, according to the building department. I'm recommending 30 days with a per diem of $50. Actually, I'd like to raise it, since they continue the work, I'd like to raise it to $100 per diem. Yeah.
In 5622, as shown by the other. 30 days to comply. If not, there will be a $100 daily fine plus.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 5637.
I see it. 2400 Southwest 30th.
Yes, 20 site address 2400 Southwest 30th Avenue, Bay B. Property owner 2400 Southwest 30 LLC. Okay, the notice violation was given on the same day as the other one, which is March 11, 2021. It was given by regular mail. The notice of formal hearing and the notice of violation was sent out by certified mail on April 29, 2021 and May 5th, 2021. The posting was done on May 10th, 2021. The violations was a stop work order. They started demolition work, electrical, structural, mechanical, plumbing without permit. Installation of a new garage door without a permit. And the ceiling and patch of walls where equipment existed without a permit. All these violations exist. And there's still no permit in the system for it. The building department did inform me that there is a permit for interior alterations. My violations were for exterior. However, there is another case that will be heard today regarding the same baby, the same matter. And that's why they pulled this permit. But it doesn't comply with the violations that was given.
Testimony and this evidence, which is unrebutted.
Okay. I was recommending that since this case, now I'm just going to recommend 30 days with a per diem of $100. Okay, case 5638.
I'm sorry, this is there's a problem here with
It's okay.
the navigation.
Okay. Chief Code Enforcement Officer Jocelyn Ramirez, case 5638, site address 2400 Southwest 30th Avenue, Bay A as in apple. Property owner 2400 Southwest 30 LLC. Notice violation was issued on March 11, 2021, and it was sent out regular mail. A notice of formal hearing and notice of the violation was sent out certified mail. I'm sorry, a copy of the notice of violation was sent out certified mail on April 29, 2021 and May 5th, 2021. The posting was done on May 10th, 2021. There are pictures entered into the record at the time of violation. A reinspection on May 10th, 2021. The violation is a stop work order. They started the demolition work, electrical, structural, mechanical, plumbing without a permit. Interior renovation started without a permit. Sealed and patched walls where doors existed without a permit. And nothing has been complied. There hasn't been any permits pulled according to the building department. I'm recommending 30 days, if not $150 per diem.
On the testimony, I find that the violations as alleged exist on the property, and I so find it flooded and create.
Okay, now we're going to page number 2, item 8. Case 5470.
5470. 5470, I'll see it.
Chief Code Enforcement Officer Jocelyn Ramirez. Case 5470, site address 2000 Southwest 30th Avenue. Property owner BKI 95 LLC, Alexander Callis. The notice of violation was given on December 3rd, 2020 by regular mail. The notice of formal hearing with a copy of the notice of violation was given May 3rd, 2021. And posting was done on May 10th, 2021. There are pictures to enter into the record that depict the violation on November 16, 2020, and a reinspection on May 10th, 2021. The violations were exterior maintenance of walls required, repairs, pressure wash, and paint. Exterior maintenance of common areas required, pressure wash, paint sidewalks, driveway, railings, steps, fence, poles. Exterior maintenance of parking lot. And the owner will have to obtain plans, permit inspections for restriping. And graffiti has to be removed. When they maintenance the walls and paint, I hope they take care of the graffiti. And at this time, the owner hasn't complied with any of the violations. They're all outstanding. I'm recommending 15 days since this violation was given on December 3rd, 2020, and I have not seen any action from the owner to comply. And $100.
The unrebutted testimony and the fact that I find that per the after
I'm all done with my cases.
But the orders I'm going to read out to you. In fact, the staff person here, you would just read out the
Well, we're actually continuing with Jeffrey's cases. I'm sorry, I didn't.
okay. No, I thought
I
you
didn't
meant that
finish.
we were-
Yeah, no, we're continuing with Jeffrey's cases, and then we're
I meant, you know, there's still some-
I'm sorry.
Okay, I understand. Okay.
And then we'll continue with Teresa's cases.
Oh, okay, all right.
Yeah. Okay. No problem. We are on page 4, number 1, case 4848,
48.
garden property. Okay. Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park, case number 4848 for garden property 786 Inc., which is also the food store, located at 2950 Southwest 32nd Avenue. This is a notice of violation in regards to sign that was installed, 3 signs that was installed without a permit. The initial violation was sent on January 9th, 2020. Notice of violation of formal hearing was sent on 5/5/2021 with certified mail and return receipt. And the affidavit of service and posting of the notice was on May 10th, 2021. We have photos to put into the record as well. And this is in regards to 3 signs. The pole sign has 2 faces, one facing north, the other one facing south. And then on the building itself, there is a cabinet sign as well. And it was a change of copy of changing the names of it. However, the electric was probably changed as well to have the light bulbs installed and everything else. So they need to have permits for the change of copy and the electrical for the lighting of the signs as well. This is considered a repeat violation since they had a formal hearing and a final order.
Same violation
For the same violation
within the past 5 years?
within the past 5 years.
Okay, go ahead.
And that's reference of case number 4985.
Or, I'm sorry, repeat?
4985. Therefore, I'm recommending 30 days. If not, then it would be $100. Sorry. $100 per diem.
Violation?
For a repeat violation? Well, actually, it could be, for a repeat violation, it should be $250.
Correct, because you just made a point of saying that they were repeat violations.
Yeah.
So I'm going to, recommendation on the unrebutted testimony, I'm going to find Garden Property 789 Inc. Fact and conclusion is law based on the unrebutted testimony and um, 30 days for compliance after a $250 after plus the $100
Admin.
yeah. So ordered, thank you.
All right. Same page, number 8, 5133.
5133. Okay.
Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park. Case number 5133 is for 24/7 Liquors, and the property owner is 3101 West Hollandale LLC. I'm sorry, 3101 Realty Corp. And the address is 3101 West Hollandale Beach Boulevard, Bay 100. This is in reference to a notice of violation for neon signs, which is a prohibited sign in our town ordinance. The notice of violation was given on June 16, 2020. The notice of violation and formal hearing was sent out certified mail and return receipt as of May 5th, 2021. and the posting affidavit of service was May 10th, 2021. At this time, the violation still exists of the neon sign, the neon lights, and the last inspection was May 12th. Recommendation is to give 10 days to remove the neon lights. To remove the neon lights? Yes. And a per diem of $50 per day until they remove it.
And I try to be uniform, but my quick question is, has 10 days been used in order? One to a few that are 15.
Mhm.
Have you used 10 before?
We've used 10 in the past, yes.
Okay. So based on the unrebutted testimony and case finding a fact and conclusion law that violations are rebutted and clients 10 days of there will be okay, plus the $100 administrative fee. Ordered in the next. Do you want to hear what orders are left here, or you'd rather just?
I think I only have one left, which is
There's
a
two.
hearing to confirm fine.
Well, why don't you again just say what they are?
4370, 4933. Yeah, 4933.
I entered it. That's a spare that's there.
Is 4370. Got it?
4370 I have. I'm looking for 4933.
4933. Here. Haven't found it yet. 4933.
Oh, 4933 is for Lakeshore Mobile Home Park. That was heard. That was one of the first ones. So that must be a spare.
That has to be a second.
Yes.
That
Okay.
one- Yes, here it is. I'm sorry, I just couldn't find it. You're right, that was heard. That must be a spare,
Extra copy.
An extra copy, in
Okay.
case, yeah.
Okay. This is it.
Yeah, that's it, but this one is,
Yeah, this one is the new one. 4370.
4370. Okay.
right, so let's hear 4370.
Perfect. Jeffrey Lewis, Code Enforcement Officer for the Town of Pembroke Park. Case number 4370, Angel Mendez, located at 145 Lone Pine Lane in Pembroke Park. This is for a hearing to confirm fine, notice of violation. And a hearing to confirm fine was mailed out, certified mail.
Too bad you don't have express on it.
On May 5th, 2021. And also, affidavit of service posting of the notice was on May 10th, 2021 as well. The hearing to confirm fine is the amount of $18,450. The admin fee is $100. The per diem is 25 days from February 22nd to March 10th, 20, which is $1,250. And then the fines picked up again in June 10th, 2020, June 10th, 2020, of 342 days to today's date of 5/18/2021. and that total is 17,100, and the total amount is 18,450. At this current time, the violation still exists. They pulled a permit for the AC in 2020, but unfortunately it expired due to lack of activity. So now they'll need to get a new permit to correct the violation. Still like outstanding. No, that's it. All three? Yes.
So I want
Out for the, to confirm fine, supplemental order?
No, I don't mind.
Right, it's a different form, yeah. So, yeah, we're just confirming the fine.
So you're gonna be here, you're gonna. Okay, so based on the unrebutted testimony, enter a supplemental order. O relief provided. That order is entered. What else do we have pending before us?
That's it. It's going to be
Teresa,
Teresa.
cases. Oh, you have your cases? Yes. Okay.
No,
Oh,
no,
you're-
no,
okay.
no,
You
no.
know, I
have
will speak out on the record on this. I want the, also the, Madam, Chief
Yes,
Code, right. My preference with your cases, don't have the orders. Want to go through the hearings, that's fine. I'll defer to you. My preference is just to wait till.
Okay, I'll like them to be heard. We'll do the affidavit of service with mail out. Prior.
Right, well then, you know, we have to know what this is because.
Okay, page 5 of the agenda, case number 2. That's 5554. Officer Teresa Malcolm, case number 554. The site address is 3100 West Hollandale Beach Boulevard, lot 210 in Pembroke Park, Florida. This is for Frank Anozio. Original notice of violation date was 3/2. Violation, the formal hearing, 5554. Formal notice of hearing along with the violation was mailed out on 4/29 with the affidavit of service posted on May 10th, as well as a reinspection on May 10th. Original notice of violation was for the wooden deck or walkway that was built or placed on the side of the home. And also an addition or screen room that was added as well as the propane tank that needed to be removed and stored properly. Upon my reinspection on May 10th, it was discovered that the addition was to an RV and not a mobile home, and nothing has been done since then. My recommendation is to give the owner 30 days to come in compliance or $50 per diem after that.
On the unrebutted testimony, officer, 5554, it is. Fine, starting on.
Officer Teresa Malcolm for the town of Pembroke Park, case number 5558. This address is at 2308 Southwest 31st Court. Owner is Gladys Manana. I apologize, I'm not sure how to say her name. Original notice of violation was given on March 2nd. It was posted to the property. Notice of formal hearing as well as a copy of the notice of violation was mailed out on 4/26/2021. Posting date was on 5/10/2021, as well as a reinspection of the property on 5/10/2021. Original notice of violation was for the windows that were changed out prior to obtaining a permit. There was doors that were changed out without obtaining a permit. There was multiple additions added to the original mobile home without a permit, as well as a wooden deck at the timing that was starting to be built without a permit, as well as a screen room or a porch that was built without a permit. Upon my reinspection on May 10th, 2021, Ms. Gladys continued to do work after she was told to obtain a permit, to stop work and obtain a permit. She then added a carport to that decking area, My recommendation is to give her 30 days for compliance. If not, then we'll do 50 days per diem.
Officer, it is found. Charge, fine and of course $100 administrative test, and it's noted for all these cases, just like this one.
Okay.
Well, I think that with all the, that's a good point, but, and for, as I said, I thought maybe too often, but as I said, for order that is, not prepared and not given to the violator at a hearing, any order, including certainly these, because they're not, plus the violator is not here, there's no way to tender, any order that the tender delivery is not made, required that the town,
Okay.
so, I mean, I think
Matter.
it's a continuing requirement.
Okay. Next case. Officer Teresa Malcolm, case number 5604. The site address is 5501 Southwest 33rd Street in Pembroke Park, Florida. The owner is Pierre as well as Edith Phillip. Original notice of violation was March 15, 2021. Notice of formal hearing as well as copy of the notice of violation was mailed on 4/29/2021. Reinspection as well as posting to the property was done on May 10, 2021. Original notice of violation was for the excessive prohibited outside storage, as well as the abandoned vehicles. The duplex needs exterior maintenance. The fence was falling as well, had a couple of tears. It appears that one of the tenant was using. Sorry, it appears the tenant was operating a landscaping business. Hence the vehicles and the landscaping vehicles that were there for advertising purposes on the property. Upon my reinspection on May 10, 2021, nothing changed. Only a couple of the abandoned vehicles were removed from the premises. The building still needs the pressure washing and exterior maintenance. A lot of the prohibited storage, outdoor stored items are still outdoor. My recommendation would be to give him 30 days to go ahead and comply. If not, we'll do 50 days per diem.
Officer, it is found and concluded that violator is actions as charged and as shown by the evidence, and liable, and they are giving 30 days to comply. If not, there will be a $50 per diem starting on the 31st day thereafter, and the $100 administrative fee, when rendered, will be mailed.
Officer Teresa Malcolm, case number 5684. Site address is 5520 Southwest 32nd Street in Pembroke Park, Florida. This is for Lyle Johnson. Original case notice of violation was given on March 23rd, 2021. Notice of formal hearing as well as copy of notice of violation was mailed 4/29. Posting date as well as a reinspection was on May 10th, 2021. Original notice of violation was for an addition that was built without a permit. my reinspection on 5/10/21 determined that nothing was done. My recommendation would be to give the owner 30 days to comply. If not, to proceed with $50 per diem.
On the unrebutted testimony of the code compliance officer, I find that the respondents are guilty of the charge based on the evidence in the record, and it is so found 30 days to comply. Not, there will be a $50 fine, $100 administrative fee. Ordered in case number 5684, which rendered be mailed by.
Officer Teresa Malcolm. Okay.
Yes.
Thank you. Officer Teresa Malcolm, case number 5700. Site address is 2000 Southwest 30th Ave in Pembroke Park, Florida, for BKI 95 LLC. Original notice of violation was written on March 24, 2021. A notice of formal hearing as well as a copy of notice of violation was mailed out on 4/29/2021. Sorry. Posting as well as a reinspection of the property was done on 5/10/21. Notice of violation originally was for all of the electrical work that was being done in the space. Interior, for full renovation of the warehouse, including the closets, the offices that were added in the main warehouse area, the demising wall, all the AC ductwork that was fully removed and replaced. Different windows were replaced, as well as verifying with the building department for the stairs and the railings for the second floor. On my reinspection on May 10th, 2021, I wasn't able to go back inside to gain access inside, so my recommendation would be for 30 days to give to the owner to go ahead and gain compliance. If not, we'll do 50 days per diem.
Recommendation of the code. Unrebutted. Find that in case number 57, the violations are violators is charged, and I so find and conclude they have 30 days to comply, and rather will be a $50 per diem fine, $100 administrative imposed, and order will so provide, which will be mailed out.
Officer Teresa Malcolm, case number 5701. This is for the site address 2400 Southwest 30th Ave, Unit B, or Bay B. This is this is for 2400 Southwest 30th LLC. The original notice of violation was written on March 26, 2021. Notice of violation as well as a copy of the hearing was mailed out on 4/26, as well as on May 5th, 2021. The original, posting to the property as well as a reinspection of the property was done on 5/10/21. The original notice of violation was a repeat violation for full tenant build out, including electrical, mechanical, plumbing, as well as structural for the office spaces that were created. Rack and pallets were installed prior to obtaining a permit. Windows were installed prior to obtaining a permit. Doors to the bathroom, as well as front and the back of the building, were done prior to obtaining the permit. Camera systems as well as the low voltage cabling for the computer access were installed without a permit. The 2 bathrooms in that unit were done prior to obtaining the permit. There was an abandoned vehicle in front of Bay B. The VIN number is on the screen for the records. New AC ductwork, as well as a chain link fence that was all done prior to obtaining a permit. Upon my reinspection to the property, I was not able to gain access inside again, but the property outside stands as is and nothing was done. So my recommendation would be to give the owners 30 days, and since they are a repeat violator, I recommend my per diem to be $250.
But what is the case where,
I would have to reference Jocelyn's case for B. Have that case number. Just that I didn't.
Five, 6, 3, 7.
Correct.
based on clients, I am going to find, one, that the violators are responsible for the violations as alleged and as shown by the evidence and are unrebutted. They will have 30 days to comply. Not comply within 30 days, a repeat violation under Chapter 7 of the Town Code has been found, and order will reference case number 5637 specifically. And that is why, by referring to that case, we have found them to be a violator, and after 30 days, the per diem, because they're a repeat violator, will be $250 a day, and the $100 administrative by imposed, and that
Malcolm, case number 5702. This is for the address 2400 Southwest 30th Ave, Unit 8 or Bay A.
what was the case number again? I'm sorry.
5702.
Okay, go ahead.
The property owner